जी
you and the other one where
ಇಲ್ಲಿ ಸೈಡಲ್ಲಿ ಇದನ್ನ ಮ್ಯೂಟ್ ಮಾಡಿ.
Nine, my lord. 29. Counsel is unwell today. He is
Not well.
not well. Week after next, if your lordship permits.
Call week of next at the request of. Entry
K.R.
ಮಾಡಿದೆಯೇನು?
K.R. Bharatwaj.
Entry ಮಾಡಿದೆಯಾ?
No interim. Please.
Serial number 34, your lordship. 34 and 42. I pray for 2 weeks' time, your lordship. In 34, stay order is there. It may kindly be extended, your lordship.
ಎರಡು ಸರಿ ಆಗಿದೆ ಇದು ಈಗ.
Lordship,
It was adjourned already na?
34
34. All right. 34 and 42.
and 42. Stay order is only for 34, your
All right,
lordship.
34 to continue.
My lord, serial number,
To
May be
the
granted, your
request.
lordship.
Okay.
Much appreciated.
my lord,
Your lordship, serial number 43.
serial number 46, my lord.
46.
It is pertaining to Shivram Karanth Lord. By mistake, it got posted, my lord.
Is it?
Kindly, it may be posted on 7th.
But ನಮ್ಮ ಮುಂದೆ ಬರಬಾರ್ದು ಅಂತ. Registry to counsel for the petitioner submits that this matter pertains to special bench of Shivram Karanta layout. First of registry to verify. All right.
Interim order is there, my
Entry more to continue.
obliged.
Your lordship, serial number 43.
For 3.
43. The issue relates to Ecom Guild matter of Supreme Court. On last occasion, your lordship had directed to, there are similar matters on the same issue. So all the matters to be clubbed together and heard. I have few matters, and also I have given a copy to Mr.
But
a learned friend. He can also, Mr. Aditya.
when it is posted. Aditya, when it is
They're all coming in the
normal
course.
but
Batch may be.
post this matter along with.
My lords, serial number 36, my lords. I may be permitted to file additional question of law today, my lords, in the counter. Matter may
36.
36, my lords.
ಇಲ್ಲೇ ತಗೊಂಡ್ಬಿಡ್ತೀವಿ.
Fine, my lord.
ಇಲ್ಲೇ ತೊಗೊಳಿಕ್ಕೆ objection ಇದೆಯಾ?
Finally,
2016.
yes, my lords. Sir.
ಇರಿ 2016 matter.
Please.
My lord,
Submit.
one pending matter, OSA 8 of 2016. Matter was heard, the part heard, my lords, in a different combination. That matter was heard
Sorry.
at length.
ನೋಡಿ ಅದು ಯಾವತ್ತು ಬರುತ್ತೆ ಅವರು ಇದ್ದಾಗ ಬರ್ಬೇಕಲ್ಲ ಜೋಶಿ ನಾವು
Indeed, my lords.
ವಿಲ್ಗಳು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
Yes. Great.
Lord, serial number 40, I pay for the appellant. I
40.
informed a week's time, my lord, that's all. It has been retransferred, reallocated. Yes. From
Ah.
Anita,
At the request of. Week after next. At the request of.
40 million.
Okay.
Much okay.
It has to
Serial
be
number
deleted and name.
I have already filed my memo for.
Yeah, fine. Okay.
Number 37 and 39 transfer pricing.
37.
And 39 is what?
Huh.
Transfer pricing issue, sorry.
37, 39.
37 and 39.
ಈಗ ಆನ್ಗೋಯಿಂಗ್ ಇದೆಯಲ್ಲ ಅದಾದ್ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಾ ನೋಡಮ್ಮ 37, 39. Call after 4 weeks. Since questions involved in these cases are being argued in other matter. Okay.
Serial number 25, my lord.
25.
Yes, my lord.
Yes, Annamalai.
In this case, my lord, before the learned single judge, they are challenged 148 notice, my lord. Their writ petition has been allowed, my lord. On one ground, it was not, it was held against me, my lord. So I have prepared the writ appeal, my lord. Even department prepared the writ appeal against the learned single judge, my lord. It is in
ಎರಡು
office
ಇದೆ ಇವತ್ತು.
objections.
ಎರಡು ಇದೆ.
Eradu ಇದೆ, my lord. May be taken up on 4th of February, my lord. It all, will make submission and delay as well on merits of the matter also, my lord. 4th of February, next week, my lord.
ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮಾಡಿ 95 ಡೇಸ್ ಇದೆ. sorry 25 ಒಂದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಇಶ್ಯೂ ನೋಟಿಸ್ ನೀವು ತೊಗೊತೀರದ್ನ
Yes, ma'am. Yes, Annamalai.
Annamalai on request accepts notice for the assessee. First, revenues appeal is filed with a short delay of 95 days and an application supported by affidavit is moved seeking its condonation. First, the explanation offered being plausible, comma, application is allowed and delay is condoned. All right. ಯಾವತ್ತು ಹಾಕೋಣ?
My lord, there is a small
February.
objection of, my lord, legible copies, my lord. It may kindly be overruled.
All right, office objection, requirement of legible copies is dispensed with for the time being. Call this matter. Fourth ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. Fourth ನಾವು ಬೇರೆ matters ಎಲ್ಲ ಇದೆ. 11th of February.
Please.
My lord, with respect to serial number 10, my lord, with respect to serial number, apologies. With respect to serial number 10, the arguing counsel was not able to be present for this honorable court today because of his aging health. Request
well.
about 2 weeks' time, my lord.
Additional affidavit ಹಾಕ್ಲಿಕ್ಕಿತ್ತಲ್ಲ. Serial number 10.
Indeed, my lord.
You're for
For the appellant.
appellant. But additional affidavit ಹಾಕಿಲ್ಲ. This was 9/12/2024 order ಅದು.
I request some time, my lord.
Ah. 2 weeks at the request of counsel for the appellant.
Much obliged.
Okay.
My lord, may permit me to move an whole writ petition pending, my lord. I appear for the respondent.
ಯಾವುದು?
There has been a stay
Which
pending.
matter? Posting.
Yes,
Sorry, next week ಹಾಕೋಣ.
my lord, may fix it.
Yes.
Much.
Serial number 38 and 41.
ಮೈಕಲ್ ಇಟ್ಕೊಂಡು ಮಾತಾಡ.
Request for 2 weeks' time.
ಯಾವುದು?
Serial number 38 and 41.
38 and 41.
Which are under final
2019
hearing.
matter.
What's it?
2019 matter.
One is 2019 matter, one is 2022 matter.
22 ಕೊಡೋಣ. 19 nuts.
19, senior has to argue this matter.
All right. 38 and 41 next week.
Much obliged.
Request of. Yes.
Lords, in this matter, I appear for the petitioner, my lords. My lords, now in this matter, what has happened is despite there being an interim order, my lords, the GST authorities have passed an order, my lords. My lords, there was an interim order. I filed an application, my lords, wherein I've sought for a direction, my lords.
Entry order ಏನಂತ ಐತಿ?
My lords, not to take any coercive steps, my lords.
4-6 steps ತಗೋಬಾರ್ದು ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿ.
My lords, of course, my lords, that is noted in the order, my lords. Now
Yeah,
case
the
it proceeds.
ಆರ್ಡರ್ ಮಾಡಬಾರ್ದು ಅಂದ್ರೆ ಆಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ ಸ್ಟೇಡ್ ಅಂದ್ರೆ ವಿ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಕೋರ್ಸಿವ್ ಸ್ಟೆಪ್ಸ್ ತಗೋಬಾರ್ದು ಅಂದ್ರೆ ನಿಮ್ ಮುಂದ್ ಬಂದು ಮನೆ ಹರಾಜ್ ಹಾಕೋದು, ರಿಕವರಿ ಫೋರ್ಸ್ ಮಾಡೋದು ಮಾಡಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ.
Please, my
ಏನಿದೆ
lords.
ಮಿಸ್ಟೇಕ್ ಇದ್ರೆ
My lords, in this, what the question is, my lords, the legal question what arises is
ರೆಡಿ.
whether, please, my lords, I have read.
This pertains to GST on works contract during that cusp period. Contracts awarded before 2017. Some work is done and thereafter, the batch is on 27th, my lords.
ಬ್ಯಾಚ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಆನ್ 27.
27th.
In fact, my lords, similar petitions were disposed of, my lords, wherein the service retainer had to pay the, my lords, amount, my lords.
No, batch
That is why my matter is linked with the writ appeal, my lords.
call this matter.
For R2, R4 and R6, lordship.
Huh?
Panel has been reconstituted, my lord. Kindly, advocate name may be changed, my lord. Office may be directed to change the advocate.
ಇದ್ರಲ್ಲ
Also,
ಯಾರು?
Arvind Chavan, sir.
ಯಾರು?
Arvind Chavan.
Shamit Deshpande is no longer in the panel.
Name of
2, 4 and 6.
2, 4.
And 6.
Yeah, who appears?
I'll appear. Arvind.
Sri, so and so appears for respondents 2, 4 and
6.
6. Okay. Amit Deshpande, Learned Counsel is permitted to retire from the case. Okay. Call these matters along with
Lords, 1.1 notice may also be issued. my lords.
1.1,
Yes, my lord.
issue notice. You will accept notice?
Central gate.
Please,
Yes,
I'll
please.
appear.
Huh? 104 respondents idara. The issue emergent notice by emergent notice. Okay.
Lords, for the union.
ನೋಡಮ್ಮ ಅರ್ಜೆಂಟ್ ಸರ್ವಿಸ್ ಆಗ್ಬರ್ಬೇಕು ಅಂದ್ರೆ ಯಾವ ಡೇಟಿಗೆ ಇದೆ ಅದು?
27th ಇದೆ.
ಓ ಆಗಲ್ಲ.
ಇಲ್ಲ, 27th
ಫೆಬ್ರವರಿ
ಇಲ್ಲ, ಜನವರಿ ಮುಂದಿನ ವಾರ.
ಇವತ್ತೇ.
Okay, sorry, correct. This is the matter.
ಆಲ್ ರೈಟ್ ಪೋಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಮಾಡ್ಬೇಕಾ?
My lords,
ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್
law post along with ನನ್ನ
ಯಾವ್ದು?
ಯೂನಿಯನ್ ಇವತ್ತು ಜೀವನ್ ಬಾಬು ನೀರಲ್ಗಿದ್ದು ನಾನು ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ನೋಡಿ ಪೋಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಸೊ ಅಂಡ್ ಸೊ ನಂಬರ್ ಕೊಡ್ತಾರೆ, ಮಾಡ್ಕೊಂಡು ಮಾಡಿ. ಓಕೆ
Great.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅದು ಇವತ್ತೇ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು.
My lords, I don't appear in that matter.
ಗೌರ್ಮೆಂಟ್
ನಾನು ತಗೊಳ್ಳಿ.
ಓಕೆ ಎಂಟ್ರಿ ಮಾಡ್ ಟು ಕಂಟಿನ್ಯೂ. ಹಾ ಸನ್ಮತಿ.
Two, my lords, I may be permitted to take notice.
Srimati Tanmay issue notice, Srimati Tanmay accepts notice for the assessee.
And this matter is also connected with serial number 11 minutes, same assessee, and she will also appear there.
I'll same 11 go same order. Call along with. Yes.
Your Lordship, I am told that needful has been done by Shishal.
Needfully stated to have been done, or registry to verify.
4 also, my lord.
Same.
Your Lordship, 5 to 8 are connected matters, my lord, same assessee,
Yeah.
where there is delay of 470 days, my lord. I have filed additional affidavit, my lord.
My oral objection may be recorded in.
Okay. ನೋಡಮ್ಮ 5 to
5 to 8,
5,
my
6,
lord.
7, 8.
Yes, my lord.
ನೋಡಮ್ಮ ಇಂಡಿವಿಜುವಲ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಮ್ಮ ಇದರಲ್ಲಿ. ಅಪೀಲ್ ಈಸ್ ಫೈಲ್ಡ್ ಒಂದು ಸಿಂಗಲ್ ಕೊಡ್ತೀನಿ, ಅದನ್ನೇ ಡೂಪ್ಲಿಕೇಟ್ ಮಾಡ್ತಾರೆ. ಆಫ್ಟರ್ ಬುಕಿಂಗ್ a long delay of 470 days. First stop. An application in application in I-1 of 2024 supported by affidavit seeks its condonation. Full stop. Thereafter, the revenue has filed additional affidavit as well. Full stop. Next paragraph. Learned counsel appearing for the assessee vehemently opposes the application, contending that a long delay like this cannot be condoned just for askance, and that there is no plausible explanation. First stop. She also points out that delay would result into accrual of some right in favor of the assessee, and that right cannot be extinguished merely because the appellant happens to be the state. First, next, having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered opinion that application needs to be allowed and delay has to be condoned since there is plausible explanation for the delay brooked in the matter. First, however, this would not happen unconditionally, and therefore the appellant is required to pay rupees 5,000.
With your lordship's kind, I will give some books, my lord.
Books.
Books, my lord. Any book your lordship
ದುಡ್ಡು ಬೇಡ ಅಂತನಾ?
ದುಡ್ಡು ಬೇಡ.
But Thomas Carlyle said, money is my God and how to get it is my religion. You don't belong to that category. Yes. ಯಾವ books ಕೊಟ್ಟಿ?
Your lordship, The Prophet by Omar Khorram, my lord, translated by Fix. It is on philosophical life, my lord.
ಬೆಲೆ ಎಷ್ಟದ? ಇದು 5,000 ಆಗೋಷ್ಟು ಮಾಡ್ಬೋಣ ಬುಕ್ ಅನ್ನೋದಕ್ಕೆ.
ಇಲ್ಲ ಬೆಲೆ ಗೊತ್ತಿಲ್ಲ ನನಗೆ.
ಮತ್ ಹಂಗೆ ಹೇಳಿಕ್ ಬರಲ್ಲ. ಬೆಲೆ ಇಟ್ಕೊಂಡು ಆರ್ಗ್ಯೂ ಮಾಡೋದಿದ್ರೆ ಅದನ್ನ ಒಪ್ಪಕ್ ಬರಲ್ಲ. ಪುಸ್ತಕದ ಬೆಲೆ ಇಟ್ಕೊಂಡು ಆರ್ಗ್ಯೂ ಮಾಡೋದಿದ್ರೆ ಒಪ್ಪಕ್ ಬರ್ತದೆ. ನಾಟ್ ಕಾಸ್ಟ್, ನಾಟ್ ಪ್ರೈಸ್, ವ್ಯಾಲ್ಯೂ.
ವ್ಯಾಲ್ಯೂ.
No, this value, no, don't value. This is great philosophical book. ಅದಕ್ಕೆ value ನಡೆಯತ್ತಾಗ.
Invaluable.
It is.
Or valueless. ನೋಡಿ, ಎರಡು ಕೊಡ್ಬೇಕು ಲೈಬ್ರರಿಗೆ.
ಪ್ಲೀಸ್.
ಅಡ್ವೊಕೇಟ್ ಆಮೇಲೆ ಒಂದು ಮೇಡಮ್ ಕೊಡಬೇಕು.
ಪ್ಲೀಸ್.
ಬಟ್ 3. ಆಲ್ ರೈಟ್, 3. ನೋಡಮ್ಮ, 2 to the library, 1 to madam. ಒಂದು ನೀವು ಇಟ್ಕೊಂಡು ಹೋದ್ರಿ, ಅದ್ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ನಾನು ನೋಡಿಲ್ಲ ಬುಕ್. ಬೇರೆ ಬೇರೆ ಹೇಳಿ, ಇದು ಒಂದ್ರಲ್ಲೇ ಅದೇ ಬುಕ್ ಬೇಡ, ಬೇರೆ ಯಾವ್ದಾರ ಹೇಳಿ.
Your lordship, another one, my lord, Sanskriti by DVG, my lord.
ಬಟ್ ಬಹಳ ಚಿಕ್ಕದದು, ಅದನ್ನ ವರ್ಕೌಟ್ ಆಗಲ್ಲ ಅದು. DVGದು ನೀವು 2 ಪುಸ್ತಕ ಕೊಡಬೇಕು. ಒಂದು ಅಂತಃಪುರದ ಗೀತೆಗಳು, ಇನ್ನೊಂದು ಭಗವದ್ಗೀತಾ ತಾತ್ಪರ್ಯ ಅರ್ಥಾತ್ ಜೀವನ ಧರ್ಮ ಯೋಗ. ಆಯ್ತಾ? 2 ಲೈಬ್ರರಿಗೆ, 2 ಮೇಡಮ್ಗೆ. 3ನೇದರಲ್ಲಿ 3ನೇದ್ರಲ್ಲಿ ಹೇಳಿ ಅದರ ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಯಾವ್ದಾದ್ರು. ಆಲ್ಕೆಮಿಸ್ಟ್ ಬೈ ಪೌಲೋ ಕೊಯೆಲೋ. ಆಯ್ತಾ? ಅದು ಒಂದು. ಇನ್ನೊಂದು ಐ ಸ್ಯಾಟ್ ಆನ್ ದ ಬ್ಯಾಂಕ್ ಆಫ್ ಪೀಡ್ರಾ ರಿವರ್ ಅಂಡ್ ವೆಪ್ಟ್. ಇನ್ನೊಂದಿದೆ, ಒಂದು ಸುಂದರವಾಗಿದೆ. ಇದೆರಡನ್ನು ಕೊಡಬೇಕು. 2 ಲೈಬ್ರರಿಗೆ, 1 ಮೇಡಮ್ಗೆ. ಆಯ್ತಾ? ಎಲ್ಲ ಆಯ್ತಾ? ಓಕೆ. 5, 6, 7, 8 ಅಲ್ವಾ?
5, 6, 7, 8, my lord.
8.
4 ಆಯ್ತು ಈಗ. ಓಕೆ, ನಾವೆಲ್ಲ ಓದ್ಬೇಕು. ಬುಕ್ ಕೊಡೋದಷ್ಟೆಲ್ಲ, ಕೊಟ್ಟಾಗಿನೇ ನಮ್ ಜವಾಬ್ದಾರಿ ಮುಗೀತು ಹಂಗಲ್ಲ, ಓದ್ಬೇಕು ಅವನ್ನೆಲ್ಲ. ಒಳ್ಳೆ ಪುಸ್ತಕ, ಪೌಲೋ ಕೊಯೆಲೋ ಬರಿತಾನಲ್ಲ, ಆಲ್ಕೆಮಿಸ್ಟ್. ಅದನ್ನ ಕನ್ನಡಿಸ್ಯಾರ ಯಾರೋ, ಆಲ್ಕೆಮಿಸ್ಟ್ ಅಂತ. ಅದ್ ನೋಡ್ಕೊಳ್ಳಿ, ಬಹಳ ಉತ್ಕೃಷ್ಟವಾದ ಪುಸ್ತಕ ಅದು. ಮೋರ್ ದೆನ್ ಬೈಬಲ್ ಕಿಂತ ಜಾಸ್ತಿ ಪ್ರಿಂಟ್ ಆಗಿದೆ ಅಂತೆ. ಚೆನ್ನಾಗಿದೆ ಅವಂದೆಲ್ಲ. He writes very good books. Jahir, ಆಮೇಲೆ Who Will Cry When You Die. So many books he has written. Wonderful ಇದೆ. Ghost. Pedra is also very good. Yes.
Your lordship, may kindly have it next week, my lord. He is not in station, my lord.
Next week. Condonation of delay 457
ಇಲ್ಲ,
days.
additional affidavit ಒಂದು ಹಾಕ್ಬೇಕು ಅದರಲ್ಲಿ.
All right. Next week. ತಿವಾರಿಗೆ ಒಂದು ಪುಸ್ತಕ ಕಂಡಿಡ್ದೇನೆ ಈಗ.
Yes, my lord.
ತಿವಾರಿಗೆ
ಹಾ.
I have found discovered one book
Yes, my lord.
by ಬಾಬು ಕೃಷ್ಣಮೂರ್ತಿ.
Yes, my lord.
ಅದು ಆಜಾದ್ ಚಂದ್ರಶೇಖರ ತಿವಾರಿ
Yes, my lord.
ಅವ್ರ ಮೇಲೆ ಬರುವಂತಹದ್ದು ಬಯೋಗ್ರಫಿ ಬೈ ಬಾಬು ಕೃಷ್ಣಮೂರ್ತಿ. ಅದೊಂದು ಅದಮ್ಯ. ವಾಸುದೇವ್ ಬಲವಂತ್ ಫಡ್ಕೆ, ಅನದರ್ ಫ್ರೀಡಮ್ ಫೈಟರ್. ಯಾವುದು? ಕನ್ನಡದ್ದೇ ಅದು, ಒರಿಜಿನಲ್ ಬುಕ್, ಬಾಬು ಕೃಷ್ಣಮೂರ್ತಿ ಅವ್ರದ್ದು. ಓಕೆ. 11 ಏನಿಲ್ಲ. Time clear, right?
Lordship, 11, my learned friend has taken notice, my lord. It is connected with serial number 2, my lord.
ಹಾ.
Tanmay appear ಆಗಿದ್ದಾರೆ.
ಯಾರು ತಗೊಂಡಾರೆ? ಸನ್ಮತಿ?
Tanmay appear ಆಗಿದೆ. Serial number 2, same, my lord.
ತನ್ಮಯಿ.
Connected with,
ತನ್ಮಯಿ. ನೋಡಿ. Science. Okay. ಏನು ಇದರಲ್ಲಿ, I think for a change, there is no delay at all. Then how to admit this? It's very unusual for you. Yes.
await notice, yes.
Await.
Appearing for the respondent, your lordship.
You appear. What's your name?
Anusha KS.
ನೋಡಿ. ಶ್ರೀಮತಿ ಅನುಷಾ. Kumari.
Kumari, sir.
Kumari Anusha appears for respondent SSC.
Kindly permit us to take notice, your lordship.
Yes, all right. Issue notice. Kumari signs accepts notice for the SSC. Okay. 13.
My lords, I appear for the petitioner in this matter.
Yes, sir.
My lords, BD
My
has
lords, I
cited
request 2
the-
weeks' time.
My lords, we made an application to vacate the interim order. The reason why I have moved the matter is for these reasons. Subject sites are allotted and CLDD is already executed. K-1 and a committee report is under challenge. Now their grievances appears to be with regard to the point of compensation is concerned. My lords, original landowner, where these persons are the purchasers from the original landowners who purchased the subject revenue sites after the issuance of the notification, subsequent purchaser. Now, original landowner has already been paid compensation. Now, my lords, K-1, my lords, they filed a writ petition challenging the acquisition proceedings. Acquisition was
ಇಲ್ಲಿ
upheld.
ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಬಂತಿದ್ದು?
ಈಗ
ಓ, ನಮಗ್ ಬರ್ತದೆ ಅದು.
my lords, now, my lords, all retired people has invested so much of money to the sites. And
Yes,
because of the
brother.
status quo order.
Your grievance is about compensation. You can't challenge acquisition because that's the law now. Acquisition can be challenged only by the khatedar, not you.
My lords, we have recently come on record, my lords, which is why I request, my lords, 2 weeks' time, my lords, we'll clarify the issue on the next date, my lords.
Next week, Madi.
My lords, I request 2 weeks, my lords.
No. Then you have to argue now. ಏನಿರ್ತದೆ?
Please,
Land acquisition matter, ಎಲ್ಲ settled principles.
Please, my lords, next week, my lords, I'll, we clarify the issue. My lords, interim order may be extended, my lords, till next week.
Call next week, interim order to continue only for 1 week.
Great.
Much obliged, my lord.
At the
Some-
request of ಮಾಡ್ಬೇಕು. Okay.
I'm sorry, my lords, can I request for a date? I'm sorry.
ಬರತ್ next week ಬರ್ತದೆ. 2023 ಮ್ಯಾಟರ್ ತಾನೆ? ಒಂದ್ ದಿವಸ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗ್ತದೆ, ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ length of the list.
With regard to the Arkavati matter, insofar as the K-1 and committee report itself is concerned, as 6th was one of the matter where my lords has granted a date on 6th.
6th ಇದೆಯಾ?
6th.
ನೋಡಿ, call on 6th.
Great.
All.
Much obliged, my lord.
Finally, at the request of counsel for the petition. Yes.
My lords, this matter originally, the impression was that the matter is a delayed filing, but the communication certificate, my lords, is at page 90.
Page 90, ಕೊಡಿ.
My lords,
Delay ಇಲ್ಲ.
delay illa.
Not pressed ಅಂತ.
I have not been served a copy.
I'll give him a copy.
It doesn't matter, but what has happened is the order of the tribunal is 2 years old. And obviously they have been served because the matter went to the full bench of the tribunal. And the full bench decided the matter, but took up the matter, but I filed a writ petition after 2 years. And then the full bench proceedings were quashed. And then they have decided to file the STRP. So there is obviously a delay. I have not served a copy.
I'll serve my learned friend.
And learned friend is aware of all these things.
ಕೊಡಿ.
So
ಕಾಪಿ ಕೊಡಿ.
formality is a purpose, delay condone ಮಾಡಬಹುದು.
ಮಾಡಿ ಹಾಕ್ಬೇಡ.
Copy will be given, my lords, immediately after.
ತಗೊಳ್ಳಿ.
I think
Petition is filed after booking a short delay of
2 years.
either
Eh,
if
Allah.
the communication certificate,
from the date of communication.
there is no delay. There is no.
But they have participated in the proceedings.
That makes no sense. For counting of limitation, reckoning of limitation, event is the factor. They have participated is no factor.
They are well aware of that judgment.
But if they seek condonation, that all this applies.
Yes, sir, true, my lords, but then technically I would submit that they participated in the full bench of the tribunal.
No, brother, that question arises
Yes,
where you want to offer explanation for the delay.
yes, yes.
What Aditya is saying is,
He received only now.
ah,
But that couldn't have been possible is by submission. It's okay. I'll leave
okay,
it.
then, Berkeley. Application was filed by abundant caution, assuming that there could be delay. First, learned AGA points out that the limitation has to be reckoned from the date of the certificate, issuance of certificate. And therefore, if that is taken into account, there is no delay. First, in view of that, we agree with this. In view of that, application seeking condonation of delay fails into insignificance and accordingly disposed of. Yes.
Sir, copies to be served.
Or you can copy.
I'll write now.
Okay.
Name to be shown.
It's unfortunate. That is what happened. Unfortunately, learned friend appeared on VC last time.
Okay.
Name was not shown, so I couldn't.
Three, science, Tirumalesh appears for assessing. Or you can copy.
Eagle 15 is the same.
Huh?
15 same issue.
14, 15, ಎರಡು same?
Yes.
No. Same order. Copies of the appeal memo are served at the brief. You ಕೊಡ್ತೀರಿ ತಾನೆ? ಹಂಗಿದ್ರೆ ಬರೀತೇನೆ ನಾನು ಮತ್ತೆ. Yes.
Lordship, there's a delay of 394 days, your lordship. On the oversight of the charter accountant, your lordship, the order.
Wait, what they will say, let us see. Same yardstick we can apply to their matters also. What do you say?
Morally, I don't have any. Right?
Notice agilva?
Notice agide.
Notice I do.
Lord, question of
Barkali.
law to be.
Application in IA 1 of 2024 supported by affidavit seeks condonation of delay of 394 days. First off, a plausible explanation is offered for the same. Which book you will give?
Lordship.
Some book you have to give to the
Yes, your
association.
lordship.
Which one?
Lordship suggested.
You
Whatever,
suggest. You suggest.
whatever lordship suggested.
No, tell one book. This is a country of libraries. 13 universities, 13 Nalanda, Takshila, Vajra, so many things. Na? Tell one book.
Ikigai. One Japanese to Ikigai. That's.
Ikigai, yes.
Ertiga.
Ikigai. Japanese.
Itiga.
Ikigai.
Ikigai.
Correct. It's very hardbound, small book. Na? It's a good book. Good
My
book.
daughter gave me to read it.
Okay. Shall give, but a small book it is. It's pricey, I think 300 rupees it was last year, maybe. Panorama, you give 5 books to association library, 1 to your friend. All right.
Lord, question of law, page number 12, requires to be admitted.
Admitted, Berkeley. Having heard, this appeal is admitted on the substantial questions of law enlisted in
Name
the
of the
appeal
book.
memo. It's a small book. It's a very good book.
Yes, your lordship.
Yes.
Much
I am
obliged.
very happy that such books are read by members of the bar.
No, it's actually very popular among the youngsters.
Youngsters.
Ikigai.
That's true. That's true.
Much
ಅದು
obliged.
ಆನಂದ್ ಬ್ಲೂ ಕಲರ್ ನಲ್ಲಿ ಇದೆ ಅದರದ್ದು ಕವರ್.
ಹೌದು,
Colour.
ಹೌದು.
I know that. I read that book actually. Yes.
Chips, the office
Tanmay?
objection is that respondent two has been made a party. He was not a party before the sestat. The submission, my lords, is that
So
he
need
was the
not be.
assessing authority who passed the order in original, therefore is a necessary party.
Council submission having accepted, office objection is overruled.
There's some urgency in this matter, my lords, if it
yeah.
can be heard. My lords, this is a matter
Ah.
where I am a purchaser of DPB scripts. My lords are aware of duty entitlement passbook scheme. This is a
No,
scheme
I
that-
do not know.
So
Just tell
this-
about that,
yes,
few
ma'am.
words about that.
This is a scheme that was introduced by the government as part of the foreign trade policy to encourage exporters. So when a,
This
when
is, this is under DGFT Act.
yes, my lords, this is under the DGFT Act. It finds itself, it's noted in the foreign trade policy. This is a remission scheme whereby an exporter who exports becomes entitled to a scrip or a credit based on the FOB value of the exports made. He gets a certain credit which he can use for payment of import duties. So instead of exempting him altogether, he gets these scripts. And these scripts are transferable. They are available in the open market. There are brokers dealing with these DPP scripts. They are dealt basically like goods. And this was a case where there was one exporter, Bilwa Labs, who got these DPP scripts. I am a purchaser of the DPP licenses. The assessee here.
It is like our TDR,
Yes, my lords.
like TDR purchasing, etc. Okay.
So I purchased these in 2009 and I made use of these for payment of my import duties. Now in 2012, there's a notice issued to the exporter saying that these DPP scripts were obtained by you by misdeclaring the goods. Basically, the allegation was that the exporter there had declared his goods as industrial salt.
From whom you have bought.
From whom I have bought through a broker in the open market. I have not even.
So
met
you
the
will not
exporter.
know what he has done, what he has not done.
I don't, and I have already utilized these scripts for payment of duties in 2009 itself. So those scripts have exhausted themselves. In 2012, they initiate a proceeding against him and cancel those scripts which are already utilized. And 2013, they initiate proceedings against me saying, now you have to pay the duty because those scripts were invalid, are held to be invalid. So my submission to the CESTAT was, I am a bona fide purchaser of these scripts. I don't know what he has declared. When at the point of time when I bought the
But
scripts.
you are a beneficiary of fraud.
But
Yes.
the point, my lords, is this is not a fraud. As at the time.
No, not you. He committed fraud.
Yes, my lords. So if this was initiated against me within the normal period of limitation, that is one thing. But they say we are using the extended period of limitation where that can be initiated only if there is collusion, fraud, willful misstatement.
With you also. Okay.
And they have accepted my submissions as regard penalty. They say that, yes, you are not liable for penalty because you were not involved in this whole transaction. And the same yardsticks equally apply for extended period of limitation because collusion, willful misstatement and fraudulent activity.
Correct. My professor of law of contract, D. Ramachandra, was a very genius actually. They said fraud, collusion, mistake, etc. To remember that, he had coined a doctrine of COFUM. C-O-F-U-M. C-O for coercion, F for fraud, U for undue influence, M for mistake. It became so easy for us in dealing law of contract, how contract is avoided. If these four are there, contract is avoided. You also used 3 of them.
Collusion.
Yeah.
Now it makes it easy for me also to remember.
Easy is difficult.
So the stay, my lords, stay application is filed. I had deposited 10% of the demand, my lords, because before the CESTAT, if I have to maintain.
You have already deposited.
10% I have. Now I'm before your lordships for stay of the balance.
Issue. Will issue a notice and stay.
Yes.
Emergent notice. Yaru, counselor.
Systems, I think it would be Mr. Jeevan Niralgi or I think Arvind Chavan also.
Yes, Jeevan Niralgi. Chavan. Yes, see Arvind Chavan. Arvind Chavan, learned panel counsel on request accepts notice for respondents. Interim order as prayed for till next date of hearing. But in law of fraud by Kerr, K-E-R-R, is one of the famous authors. He places beneficiaries of fraud also in a vulnerable position, subject to exceptions. That way,
My lords,
bona fide,
like I was
etc.
saying,
But only thing is, as you said, you have paid to him.
Yes,
Number 2, you have already exhausted them.
Yes.
Therefore, at this
the
stage,
other
what
thing
should happen is the factor.
are treated as goods. And my lords are aware under section 19 of the Sale of Goods Act, if I'm a bona fide purchaser of a voidable contract, which has not yet been avoided.
Avoided.
Yeah, I'm a beneficiary of a voidable contract. My lords, if section 19 is seen, section 29, when the seller of goods has obtained possession thereof under a contract voidable under section 19 or section 19A of the Contract Act, but the contract has not been rescinded at the time of the sale.
Not yet voided.
The buyer acquires a good title to the goods, provided he buys them in good faith and without notice of the seller's defect of title. Here they've accepted my case that I am a bona fide purchaser.
Question is whether the subject involved is goods or not is the question.
That has been decided by Supreme Court, my lords.
Is it?
Scripts have been held to be goods.
Oh. Then you have appeal task. See, she argued so well. Thank you.
Great.
Okay. In Prakash,
The deadline was fixed for compliance of the order, my lord, for the second time in the contempt petition. Your lordship was also
We
part of
pass
the.
it over, your lordship.
We'll revive the order, then let it come, main matter come. Prakal.
Now, in the meantime,
This
I'm told that-
complaint was disposed of by a bench in which one of the members of this bench happened to be a member. Wide order dated 7/9/2023. First, that order reserves liberty to the complainant to seek revival. Idea?
Oh, there's a liberty.
Seek revival. First up, para 3 of the order reads as under. Next paragraph. An application is moved, supported by an affidavit seeking revival of the complaint, alleging that there is no compliance of the order in question. First up.
Now, may I interrupt for a moment? After the representation was given, copy was served. Let me be, they did contact us over the telephone and said, you come and contact us, and suggested 4 sites. Thereafter, they have got in contact with the complainant. So I may request at this juncture, my lord, let the at least 10 days time may be fixed. If they don't do anything further, then it can be revived.
ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ
Revive ಮಾಡೋಣ, ಅವ್ರು ಬಂದ್ಕೊಂಡು ಹೇಳಿ.
ಬಂದ್ ಹೇಳಿ.
In the above circumstances, this application is allowed and CCC number 368 of 2022 allowed, and the order dated 7/9/2023 is recalled. So as a consequence, CCC number 368 of 2022 is restored to the board for consideration afresh. You appear ಆಗ್ತೀರಾ? ಎದ್ಬಿಟ್ಟು ತೋರ್ಸು. Call after 2 weeks. 2 weeks ನಲ್ಲಿ ಹೇಳ್ಬೇಕು. Okay.
Additional, your application for additional substantial question of law and ground has been filed, my lord, for amendment, my lord.
ಅಲ್ಲ ಮಾಡೋಣ ಅಥವಾ along with main matter ತಗೊಂಡ್ಬಿಡ್ಬೋದು.
Either way, it can be taken. It may be pending admission or amendment. The application may be allowed, my lord. I will file amended petition.
Application in IA number 2 of 2024 seeks amendment of the petition. First up, it is supported by an affidavit. First up. Matter is not much advanced. First up. Following application would do justice, both the sides. First up. Dismissing application would do injustice to the petitioner. First up. Next one. In the above circumstances, application is allowed and leave to amend as sought for is accorded. All right. Amended petition to be filed within 2 weeks.
Yes, ma'am.
Okay, right, okay. Allon sentence very good, but that AG opposed the application.
Please, my lords, I'm appearing on behalf of the respondent, item number 20 and 21.
20?
My lords, we were served with a copy of the appeal only.
ಏನಂತೆ?
Copy you have received.
But you haven't received a copy of the condemnation application.
Condemnation application. You one more copy, what is there?
It is given.
Padi.
Your lordship, both are connected, my lord. 20 and 21 are connected, my lord. In one, there is delay of 245 days, my lord. In another one, it is 300, my lord.
300. Yes, we'll condone delay, brother. subject to giving some books to you. All right? Barka. Madam. Application in IA 1 of 2024 seeks condonation of delay of 245 days brooked in filing the appeal. A plausible explanation, first, it is supported by an affidavit. First, a plausible explanation is offered. First, the net counsel appearing for the assessee opposes the application. First. Next, having heard the learned counsel for the parties and having perused the appeal papers, we are inclined to allow the application in as much as the explanation offered for the delay is plausible and that more older matters than this are still languishing in the court cupboard. First off, it is not that if the appeal was filed in time, by this time, it would have been heard and disposed of. First off. Next, in the above circumstances, application is favored and application is favored and a delay of 245 days in filing the appeal is condoned, subject to which book you will give to him.
Lordship, autobiography of Yogi, my lord, by
So Paramahamsa Yogananda. That's a good book actually. Shall present autobiography of a yogi by Paramahamsa Yogananda. 2 books to the association library.
1 book to the.
All right, 1 book to the association library and 1 book to your friend. All right, but you should also read.
Yes,
He was a great friend of Sir Jagadish Chandra Bose, Tagore, all these people. And his body did not decay for 55 days in America. A certificate has been issued by the cemetery in charge. It's a strange thing that human body did not decay. Such a great person. Just look into it. It's a very interesting book. All right. There's another book on par with that. There are many books. I'm telling one more book. Living with Himalayan Masters by Swami A. Rama. That's also like that. Just see them. Okay. That this book mentions the famous poem Illusion by Ralph Waldo Emerson. This book quotes that one. Just look into that. His interaction with Tagore, J.C. Bose, so many things he has given. That's good book. Next one.
One indulgence, my lord, 20 and 21. I was earlier on Wakalat for the respondent. My name may be deleted. I'm no longer associated.
Name of Sri Aditya, we bet to be deleted. Okay.
NOC is already filed, but for some reason it appears.
NOC is filed. Permitted to retire. Okay. And delete. Next, another is 300 days.
Connected matter. Same.
My lords, I'm sorry.
You give one good book. 100 Days of Solitude, not 300 days, by Gabriel Garcia Marquez. He was president of Czechoslovakia also. One of the best books. He's a Nobel Prize awardee. Nadi.
My lords, I just assumed, so the order in both the appeals is a common order. And out of that common order, they're filing appeal after 245 days in one matter and 300 days in the other matter. So that's the only reason why I was requesting for the IA.
Many things happen with lot of delay in life. Maybe education, employment, marriage, childbirth. These things are there. Anyway, you'll get one good book. One book to library, another book to your friend. Gabriel
these matters
Marquez.
These matters will be called out after.
You tell whichever date you want.
After 3 weeks.
3 weeks is fine.
3 weeks. All right. Call after 3 weeks along with each other.
Please.
Okay. What's your name?
Anmol Anand, Advocate Anmol.
It appears you are from North.
I'm from Delhi.
Delhi, yes. By your voice and look, I could make out. Very well.
Much obliged.
Wonderful. All
The short delay, my lord. 29 days.
29 days. 1 month. 1 lunar month in Mohammedan law. 29 days. Anyway, ನೋಡಮ್ಮ, delay control, just structure that. Okay.
Lordship, the matter may be admitted to consider the substantial question of loss.
There are TP questions.
TP questions as well as
Appeal
not
is,
TP issues. also
heard.
there is not.
Heard both the sides. First, heard on admission. First now. The appeal is admitted on the following substantial questions of law. ಯಾವ್ದ್ಯಾವ್ದು?
All questions shown in paragraph number 12, my lord.
All questions, para 12 then. Which read as under. ಎಲ್ಲೆಲ್ಲಿ ಈ ರೀತಿ ಮಾಡ್ತೇವಲ್ಲ, reproduce ಮಾಡ್ಬೇಕು.
Is this one numbering error? It's actually there are 7
It is
questions.
corrected, I
It
think.
says-
It is corrected.
Correct.
ಇದ್ರಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
1 to 6 ಅಂತ ಹೇಳಿದ್ದಾರೆ. It's
Okay.
actually 1 to 7.
1 to
Just
7.
go through that one. If there is any correction, I will. do it.
ಅವ್ರದ್ದು
I will
ಮಾಡ್ಕೊಟ್ಬಿಡ್ಬೇಕು.
do it. my lord.
Okay.
That's it.
ಹಾ. 23.
Only 15 days delay in filing the.
ಹಾ. ನೋಡಮ್ಮ, delay control.
Notice first matter.
Notice.
I'll accept.
ನೋಟಿಸ್ ಮಾಡ್ಬೇಕು, ಆಮೇಲೆ ಡಿಲೇ ಕಂಟ್ರೋಲ್ ಮಾಡ್ಬೇಕು. ಅಡ್ಮಿಟ್ ಮಾಡ್ಬೋದಾ?
Maybe add next week for admission.
2 weeks.
Along with penalty, identical matter.
ಹಾ. Along with,
STN number 01/2024.
call along with so and so.
1/21. Okay.
ಹಾ.
In this case, I am the respondent number 3. I am the complaint before the land grabbing court. The land grabbing court has taken cognizance of regarding encroachment of the land by the petitioners. My lords, in the land grabbing court.
Are you for petitioner or respondent?
I am here, my lord. Here, respondent number 3, we filed application for vacating the order passed by this honorable court.
Okay.
And this honorable court granted liberty to file.
ಏನ್ ಮ್ಯಾಟರ್ ತಗೊಂಡು ಹೇಳಿ.
My lord, the last occasion, if my lords were to kindly peruse the order. My lord, there was a direction, my lord, issued to the Tahsildar.
Tahsildar has submitted their report stating that this land has not been granted in their favor, my lord.
Filed a report on 25/9, my lord, along with the translation part.
Tahsildar's order.
28/11/23 is order of the Tahsildar.
My lord's order on 30th of October, where my lord, an interim order was granted by this honorable court.
How you got this land?
My lord, that today
Not ready.
prepared, my- please, my.
Next week ಮಾಡಿ.
Ma'am.
Date. In urgency, you are only complainant. Call after 2 weeks.
May I request interim order may kindly.
Interim order to continue. Till next date of hearing.
Because idರಲ್ಲಿ some other sale transaction taken place. It is learned that based on.
You are
my-
only
my-
complainant.
I-
You are only complainant.
Yes, yes.
Your complainant's rule is under the act to bring it notice to the court. Notice of the
ಏನಂತಂದ್ರೆ ಈಗ ಸೇಲ್ ಡೀಡ್ಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿರೋದ್ರಿಂದ ಜಸ್ಟ್
court.
ರಿಕ್ವೆಸ್ಟ್.
ನೋಡ.
He is on his legs in other court, my lord. Delay
Other
may
court.
kindly be condoned, my lord.
Huh?
Delay may kindly be condoned.
Notice ಆಗಿದೆ, notice. Okay. Well, emergent notice ಮಾಡ್ಬಿಡಿ ಎಲ್ಲ. Notice means emergent notice. Okay. 27.
My lord, there is a delay of 341 days.
Ah.
Last occasion, your lordship had said that if the advocate who had, this delay is caused because of the advocate.
Your assertion is not true. We held a discreet inquiry. But 36 or 37 cases she has filed.
7 cases.
Yes. Inquiry report ಕೊಡಿ. ಕೊಡಿ, ಅವರಿಗೆ ಕೊಟ್ಬಿಡಿ. We can't condone delay on false grounds. ನೋಡಿ, ಎಲ್ಲ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಟ್ಟೇವ್ರು. ಯಾಕೆ ಇದು ಮಾಡ್ತೇವೆ ಅಂದ್ರೆ ಏನಾದ್ರು ಇನ್ನೊಂದ್ಸರಿ ಯಾರ ಸುಳ್ಳು ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ.
My lord, I'll just bring.
ಅವ್ರಿಗೂ ಕೊಡಿ, ತೊಳಿ. ಇವ್ರೆ, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಅವ್ರಿಗೂ ಕೊಡಿ, ಅವರು ನೋಡ್ಲಿ ಇಬ್ರು. ಏನಂತದೇನು ಮುಚ್ಚಿಟ್ಕೊಳ್ಳೋಂಥದ್ದು ಇಲ್ಲೇ ಇಲ್ಲ ಅದ್ರ. She has filed innumerable cases. She had attended the court, except in one case. How can that be a ground for condonation of guilt?
Then she herself has filed the affidavit.
Actually, she should be proceeded against her. Anyway, we don't want to do that.
Just
To
bring
be-
one notice fact to this honorable court, my lord, that writ petition order, the copy application itself is filed in 23, my lord. Department, we have processed it as soon as possible, we have filed it. But ಅದು ಒಂದು ವರ್ಷ ಆಲ್ಮೋಸ್ಟ್ 8 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಫೈಲ್ ಆಗಿದೆ ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. ಸೊ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಆ ತರ ಇದು I humbly pray delay will control.
I leave it to your lordships.
Why should he be punished for that?
I leave it to your lordships.
ಯೂಸ್ ಮಾಡೋ ಕೆಲಸಕ್ಕೆ ಸ್ಟೇಟ್ಗೆಲ್ಲ ನಿಜ ಹೇಳಿ ರಾತಪ್ಪ. ನಮ್ದು ಏನು ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಮೋಟೋ, ದೋ ಇಟ್ ಈಸ್ ನಾಟ್ ರಿಟರ್ನ್ ಇನ್ ಅವರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಔಟರ್ ಕವರ್ ನಲ್ಲಿ ಇದೆ ಅದು. ಏನು ಸತ್ಯಮೇವ ಜಯತೆ, ಇಲ್ಲಿರೋದೇನಿದು? ಹೌದಾ? ಸತ್ಯಮೇವ ಜಯತೆ, ನಿಜ ಹೇಳ್ಬೇಕಲ್ಲೆಲ್ಲ. ಹಿಂಗಾಗಿದೆ, ನಾವು ನಿಜ ಹೇಳಿ ನಾವು ಹೋಗ್ಬಿಡ್ತೀವಿ. ಇಲ್ಲ ಅದು ಹಿಂಗಾಯ್ತು. ಮೊನ್ನೆ ಯಾವುದೋ ಒಂದು ಕೇಸ್ನಲ್ಲಿ 2 years ಆಡಿತ್ತು ಡಿಲೇ. ಅವ್ರು ಹೇಳಿದ್ರಿಲ್ಲ, ನಂಗೆ ಅದು ಯಾಕೆ ಹಿಂಗಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ಏನೋ ಬೈ ಮಿಸ್ಟೇಕ್ ಏನೋ ಆಗಿದೆ, ಬಟ್ ಜನರಲಿ ನಾವು ಹಿಂಗೆ ಮಾಡಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡು ಇಮಿಡಿಯೇಟ್ಲಿ ಕಂಡೋನ್ ದ ಡಿಲೇ.
Very rarely, sometimes we also.
ಅಷ್ಟೇ. ಏನು ಆಫ್ಟರ್ ಆಲ್ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋದ್ರಿಂದ ಏನು ನಾವೇನು ವಿ ಆರ್ ನಾಟ್ ಪುಲ್ಲಿಂಗ್ ಡೌನ್ ತಾಜ್ ಮಹಲ್ ಟು ದಿ ಗ್ರೌಂಡ್, ಈಸ್ ಇಟ್ ನಾಟ್? ಅಷ್ಟೇ. ಒಳ್ಳೆ ಬುಕ್ ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ, ಒಳ್ಳೆ ಪುಸ್ತಕ. ವಿಚ್ ಬುಕ್ ಯು ವಾಂಟ್ ಬ್ರದರ್?
Lordship, any commentary on GST would.
ಒಂದು ಕಮೆಂಟ್ರಿ ಆನ್ GST ಕೊಟ್ಬಿಡಿ.
Anything, I leave it to lordships.
No, Papi has asked book. ಕೊಡಿ ಬುಕ್. ವಿದ್ಯಾದಾನದ ಮುಂದೆ ಇನ್ನೊಂದಿಲ್ಲ, ಬುಕ್ಸ್ ಅನ್ನು ಹಂಚಬೇಕು. ಶಿರ್ಸಂಗಿ ಲಿಂಗರಾಜರು ಅನ್ಕೊಂಡು ಉತ್ತರ ಕರ್ನಾಟಕದಲ್ಲಿದ್ದು ರಾಯಲ್ ಫ್ಯಾಮಿಲಿ ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿನ ಈ ಎಜುಕೇಶನ್ಗೆ ಕೊಟ್ಬಿಟ್ರು. ಈ KLE ಸೊಸೈಟಿ ಇದೆಯಲ್ಲ, ಫಸ್ಟ್ ಕೊಟ್ಟರು ಅವರೇ. ಈ ಡೊನೇಟೆಡ್ ಆಲ್ ಪ್ರಾಪರ್ಟಿ, ಏನೇನೋ ಇಟ್ಕೊಳ್ದಂಗೆ. ಕೊನೆ ಕಾಲದಲ್ಲಿ ಅವ್ರಿಗೆ ಬದುಕೊಳ್ಳಿಕ್ಕೆ ಬೇರೆಯವ್ರ ದುಡ್ಡು ತಂದು ಕೊಡ್ಬೇಕಿತ್ತು ಊಟಕ್ಕೆ, ಆ ರೀತಿ ದಾನ ಮಾಡಿ ಹಾಕ್ಬಿಟ್ರು. ಹೀಗಾಗಿ ಪುಸ್ತಕ ಕೊಡ್ಬೇಕು. ಬರ್ಕೊಳ್ಳಿ. Appeal is filed after booking a delay of so days. First stop. An application is filed supported by the affidavit of erstwhile panel counsel. First stop. The contents of the affidavit, although do not much appear to be true, we need not spend time on that. Regard being had to merits of the matter and shortness of delay as well. First, learned panel counsel appearing for the revenue graciously offers to present one book of GST, latest book of GST, along with commentary diya?
Commentary ಇದೆ.
Along with commentary. Two learned counsel appearing for the assessee. First off, it's a good gesture, please. Good gesture from both the sides. First off. Next paragraph. If delay is not condoned, revenue would be put to injustice. Condonation of delay would not add any merits to the case to the advantage of the assessee. First off, older matters are still languishing in the cupboard of the court. First off, explanation offered is plausible. Okay. Application is allowed. Delay control. Okay. The report filed, the discrete inquiry report filed by learned registrar judicial is taken on record, and this court places its a deep appreciation for the timely work done by the registrar judicial Srimati so and so. First.
Lords, for the respondents, my lords. My lords, I was informed there was other similar matters on the same subject matter coming up.
Are there?
It may be taken up
ಯಾವ್ದು?
along with
ಕೊಡಿ.
those matters.
Number ಇದೆಯೇನು?
My lords, I'll produce those, my lords.
My lord, there are various, this issue pertains to section 7410, where a common show cause notice can be issued or not in respect of 3 years or 5 years, my lord. Section 73 speaks about 3 years. Section 74 speaks about 5 years, my lord. That is suppression and all. So, my lord, now this learned single judge has held that you cannot issue common show cause notice. You have to issue separate show cause notice for separate financial periods, my lord.
ಯಾವ್ದಾದ್ರು ರೂಲಿಂಗ್ ಫಾಲೋ ಮಾಡ್ಯಾರ?
Adu ruling has been followed by the same jurisdiction high court single bench by following a Kerala High Court judgment, my lord. My lord, now there is one more Kerala High Court judgment which says, which has distinguished the Kerala High Court judgment and this honorable court, saying that nowhere in the section it says that separate show cause notice has to be issued. Always the adjudication, that is assessment order, will be done separately. Yes.
Legal position ಏನಿದೆ?
Madras judges followed the Madras High Court went on the principle that the limitation provided under section 73 and 74 of the GST Act is defined with reference to the last date to file the annual return for each year. So going by that in a common order, so therefore in one order,
ಅದು ಯಾವ್ದು ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಎಲ್ಲ ಕೊಡಿ.
It's
This reasoning appears to be sensible. ಮೊದಲೇ ನಿಮ್ದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಲಾ ಇಷ್ಟು ಕಂಬರ್ಸಮ್ ಇದೆ, ಅದು ಐನ್ಸ್ಟೈನ್ ಬಂದ್ರು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಸಾಧ್ಯ ಇಲ್ಲ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ GST ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ, we give only show cause notice, but the orders are individual. In the show cause notice also, our officer, adjudicating authority officers try to segregate the tax period and the taxable amount
So it
to be
is
demanded.
intelligible to the, it is easily understandable by the
Please, my lord.
assessee.
And in fact, in many matters, I have filed one more matter where after issuing show cause notice, we issue summary show cause notice, my lord. In the summary show cause notice, the officer has separated all the financial years, 5 financial years. So the grievance of the assessee is that you don't separate everything. I will be overburdened to work out all 5 years and give a reply which will
So
be
give
harsh.
comprehensive notice covering all.
Anta. ಅದಕ್ಕೆ we give all one notice but separate speaks about common show cause. It only speaks the assessing officer when to pass the orders within such a date. Now the honorable court has interpreted that no, this has to be extended to the say that common show cause notice itself cannot be issued.
Generally, there is a famous book by 2 books. One is Law of Notices. That is Majumdar's famous book it is. He says plurality of notices need is not the rule. If notice issued gives full particulars to the knowledge of the noticee, anta hold ಮಾಡಿದ್ದಾರೆ. This is pursuant to one famous judgment of Calcutta High Court Judge, Justice the PB Mukherjee, as his lordship then was. ಆ ರೀತಿ ಇದೆ. Anyway, requires
Because
consideration.
the law mandates is that, madam, whenever we issue show cause notice, we have to put the assessee on notice that see for all these.
And he can say, no, I don't understand this notice, give individually ಅಂತ ಹೇಳ್ಬೋದು. ನೋಡಿ ಮಡ್ರಾಸ್ ಏನೋ ಇದೆ, ಕೇರಳದ ಏನೋ ಇದೆ. Let us see that. ಯಾವ್ದು
28, my lords.
Admit ಮಾಡೋಣ.
Please.
Heard. Admitted. ಯಾವ್ದದು ಕ್ವಶನ್ ಹೆಂಗ್ ಫ್ರೇಮ್ ಮಾಡಿರಿ?
Writ appeal.
ನೀವೇನು ಇವ್ರಿಗೆ ಇಷ್ಟೇ ಕೇಸ ಇದು, ಇಷ್ಟೇ ಕೇಸ್ ಇದ್ರೆ ಮುಗಿಸೇ ಬಿಡ್ಬೋದು. Are you ready?
No, my lords.
You're not ready.
ಬೇರೆ matters ಇದೆ.
ಬೇರೆ matters ಯಾವ್ದಿದೆ?
We'll try to list it.
All right. Call this matter along with other connected matters, list of which should be furnished by panel counsel, Mr. Chauhan. Okay. Week after next.
Grateful.
And ತೊಂಬರ್ಬೇಕು, Law of Notices. It's very good book on the standard book on law of notices. The same author has written another book, The Plaint, Only plaints. You will see PC, Moga, Shivgopal, Archbold. You will find the plaint and written statements. This is only plaints. Class write-up on par with Archbold's pleadings in England. That way. Yes.
My Lord, I appear for the petitioner, my Lord. Proceedings initiated under land grabbing, my Lord. My Lord, I'm a BDA contractor. My Lord, I constructed Nayanhalli Passover, my Lord. That was granted. The award was in my favor in the year 2011. 2014, I completed the work. For that purpose, a piece of land was given to me to keep my machinery, which I have returned in 2014. Lord, there is a suo motu proceedings initiated in 2017 before the court. And in that, my Lord, 5/8/2024, my Lord should find that order at page 68. Based on a statement made by PW2 in the evidence, Lord, I have been impleaded. I am not in possession of any land. Work is completed. Lord, it is returned. In fact, Annexure D, which is a report of 2017, dated 17/8/2017, at page 78, is a report by my Lord the Tahsildar, which shows who are in possession of this survey number 117, page 78, my Lord. There are 4 persons, my Lord, who are mentioned at page 79, who have put up some shed there. Lord, that is the report, factual report. BDA had given me possession, my Lord, for a very brief period for the purpose of keeping machinery, for the purpose of construction of an underpass,
But shed,
which was over in 2014. No, my Lord, put up any shed. My machinery was there, my Lord, historically, my Lord, between 2011 and 2014. 14, I have vacated, my Lord, given it by BDA, my Lord. After that, my Lord, there is nothing belonging to me in this property at all. And the report also indicates, my Lord, that I am not in possession. Page 79. This is of 2017 report.
No,
that itself confirms.
It's 2011. If you are in possession of, yes, if you are in possession of the property, public property, and if you do not account for your possession, then you are an offender.
Lord, 2011, Lord, it was given to me by BDA. Lord, to say that temporarily, 2011, Lord, it was given to me by BDA. Lord, that is the work order, my Lord. I have produced the work order.
Where is that?
Which is at page, Annexure C, page 71. This is for construction of Outer Ring Road, page 71. This work order is of 2009. Completion was 2011. It got delayed because of land acquisition issues, my Lord. Matter got dragged, but my Lord, I completed the work.
But at least, you could have produced it before the court, saying that.
Lord,
See,
now
this
I
is
have,
the position
Lord, I have
you
now,
allow me to.
Lord, I have appeared, my Lord, now appeared before the court, but my Lord, prima facie, my Lord, because the Tahsildar's report itself indicates, my Lord, that I am not in possession. Just
You are
because
not in
historical.
possession. No,
my Lord, I am not in any, my Lord, I have had this property only through BDA, my Lord, for a very brief period. My Lord, I have given it back to BDA. And my Lord, 2024, my Lord, contrary to Tahsildar's report, my Lord, proceedings is initiated by impleading me as an accused.
Issue emergent notice. Tahsildar, learned AGA. Tahsildar idaru. You appear for learned AGA on request accepts notice for the respondent. Interim order as prayed for. Till next date of hearing. Adu beda hing nodama. Stay of all further proceedings in LGC into brackets S number 179/2017 pending on the file of special court for prohibition of land grabbing in Karnataka, comma, insofar as petitioner is concerned. First. Okay.
Grateful.
Avri copy ಕೊಡ್ಬೇಕು.
Yes. I'll have.
Avri copy ಕೊಡಿ.
Yes.
Yes. Hello. Order shall not be released. Interim order shall not be released till a copy of the petition is served on the learned AGA and acknowledgement is filed in the registry. Okay. Rachappa, ಏನಿದು?
The authority has restricted the labor, as a petitioner is involved in the activity of in the activity of supply and installation of the lift and elevator products.
Supply and installation.
Installation of
Works contract ಇದ್ದಂಗೆ ಇದೆ.
Please, works contract. In this case, the labor charges is been restricted to 25%. Without going into the facts of the case, they have restricted the labor charges to the effect of 25% only, and on the entire value of the contracts, they have imposed the VAT. This is the whole issue.
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟಿರ್ಬೇಕಿತ್ತು?
They have to go through the books of accounts. What is the
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು percent? ಅವ್ರು 25% ಮಾಡ್ಯಾರಪ್ಪ. ನೀವು ಜನರಲ್ ಟ್ರೆಂಡ್ ಎಷ್ಟು % ಇದೆ ಇಂಥ ಕೇಸಸ್ ನಲ್ಲಿ?
Please, another 10 to 15%. Depends upon.
Lordships may kindly see, under the VAT rules, I am required to restrict it actually to 15%.
But they have done it 25%. 15% or more, whichever is less.
On the labor charges. Such amounts calculated at rate specified in column 3 of the table below towards labor charges, other like charges, execution of works contract, when such charges are not ascertainable from books.
No, if it is not ascertainable from books, he says
all the
it would have been ascertained from the books only.
Please.
That would exceed 30%, 25%, 40% ಅಂತ our contention.
Please.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Even for that also it is provided, madam. All the amounts actually expended towards labor charges and other like charges and not involving any transfer of property of goods in connection with the execution of works contract, including charges incurred for erection, installation, fixing, fitting out, or commissioning of the goods used for the execution of work contract. Actually expended, it has to be appreciated.
ನಿಮ್ಮ books of account ಇಂದ ಅಂದ್ರೆ ಅವರಿಗೆಲ್ಲ ಚೆಕ್ ನಿಂದ ಕೊಟ್ಟಿರೋ ದುಡ್ಡು. How have you paid the amount?
Check only.
Show that. Where have you stated? Amount is paid to the laborers. Check. Show that. You may write anything there. Sir, your pen and your ink. Where have you stated? Rule says 15%, unless you prima facie show from the books that some more amount is incurred for that.
Previously, my lords, assessing officer has passed an order, and they were of the opinion there was the matter was remanded back to the assessing officer again from the joint commissioner appeal, where he had find out the sale of elevators and proposing to levy of tax on the entire consideration received by the contractees. The appellant had treated the transactions affected by the execution of the works contract, supplies, installation, testing, commissioning elevators, accordingly claimed the deduction towards the labor charges, total consideration received. Moreover, we have also produced the works contract and other invoices for the JC.
Works contract nage estiде idra amount payable to the labor, payable for the labor.
20% of CV.
Even more.
The composite what is we have stated, my lords. Whereas we have produced the invoices before the assessing officer assessment. Works contract merely contains what is the scope of works and all those things. Whereas the invoice contains the details. If it is verified, that would be known.
ಅಲ್ಲ ವರ್ಕ್ಸ್ ಕಾಂಟ್ರಾಕ್ಟ್ ನಲ್ಲಿ ಒಂದು ಲಿಫ್ಟ್ ಅನ್ನ ಇನ್ಸ್ಟಾಲ್ ಮಾಡೋದು ಅಲ್ವಾ? ಅದರಲ್ಲಿ ಲಿಫ್ಟ್ ಚಾರ್ಜಸ್ಸು ಪ್ಲಸ್ ಇನ್ಸ್ಟಾಲೇಷನ್ ಚಾರ್ಜಸ್ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಬರ್ತದೆ ಇನ್ಸ್ಟಾಲೇಷನ್ ಚಾರ್ಜಸ್? ಲಿಫ್ಟಿಗೆ ಎಷ್ಟು ಅಮೌಂಟ್? What is the amount? Because I have also put lift to my law office long ago. That we can work around. Still, when how much amount you have? The entire works contract is for what? Total amount is.
In fact, if it is his case that it is composite, then under sixth schedule entry 23, 14.5% is leviable straight away, my lords. There is no breakup. There is no breakup. My learned friend's case is that it's a composite contract. Lord, and Supreme Court in
Works contract or composite contract? There is difference.
elevators, my lord, is a composite. There is no split up of work, material, labor.
No, what's the difference between works contract and composite contract?
My lord, there is a element of transfer of property in the
Works
elevator.
contract.
No, in the composite contract. There is no distinction between the services provided and in addition the
No earmarking, etc. It's a
composite. Whatever infrastructure is put up, the elevator shaft is given, the cubicle is given, the motor is given. My lord, Supreme Court says let me learn it. Kone elevator, my lord, Supreme Court 2014, elevator is treated as composite.
Elevator, that is called a composite contract, not works contract.
Then it says that it is not possible for me to weigh the proportion anymore.
Is a works contract, my lord, by going.
No, how to say it, this is a works contract, this is not a, it's a only composite contract. How, where is it defined? Which is that famous case of Apex Court decided decades ago. Canon Dunkerley? Canon Dunkerley, na? Works contract. Yes, explain to us the idea. We are freshers to taxation law. What is a works contract? What is a composite contract? If rule speaks of, whether rule speaks of works contract or it speaks of composite contract. How? Where is the definition of works contract?
Works contracts includes any agreement on for carrying out cash, deferred payment, or other valuable consideration, building, construction, manufacture, processing, fabrication, erection, installation, fitting out, improvement, modification, repair, commissioning of movable and immovable.
So it's it involves goods and services, both. ಅದರ ನಡುವೆ goods ಗೆ ಎಷ್ಟು ಕೊಟ್ವಿ, services ಗೆ ಎಷ್ಟು ಕೊಟ್ವಿ ಅನ್ನೋದು the idea. Now that one. Which is that?
Your lordship, before the judgment, my lords, may kindly take section 4, the act.
Buddy.
I'll take your lordships to the judgment, but lordship may kindly take section 4 of the act.
It is feeling transit. Works contract. Is a work contract. You are saying that you are on deliver reduction. Then you can deliver reduction. But I use an argument that it is feeling transit.
Liability to tax it.
Yes, sir. Every dealer who is or is required to be registered as specified in section 22 and 24 shall be liable to pay tax on his taxable turnover. Your lordship may straight away come to C.
C.
In respect of transfer of property in goods, whether as goods or in some other form, involved in the execution of works contract 2 of the 6th schedule, subject to sections 14 and 15 of central sales tax, rate specified at corresponding entries in column 3 of the said schedule. 6th schedule, my lords,
The rates have been specified.
Rates have been
They are
specified.
not negotiable at all.
They're not negotiable at all. And what
What
happened,
schedule is, page number?
my lords, in my book, it is at 111. I don't know if your lordships. It is immediately after the statute, before the rules, my lord.
Fifth schedule, sixth schedule. Yes. Sixth schedule, item number?
Item 23, my lords. Because here elevators are not specified, my lords.
All other works contracts not specified in any of the above categories, including such, it's a fixed amount. 14.5.
That's the rate of that.
Nowhere the breakups are given here.
No breakups.
Yes, brother.
And then, my lords, para 70 of the judgment that I have.
It's a fixed percentage. Tirumalesh, fixed ಇದೆ. Negotiable ಇಲ್ಲ.
The argument canvas is that it is, they have executed works contract and they are asking for labor reduction.
Where is the provision? Provision says 23, item 23. It's a fixed commodity.
All other works contract, 23 melodies.
Correct.
All other works contracts specified in any of the.
Not specified in any
Not
of the above.
Not
You have to
specified.
show in which it is be specified now. Only then you are entitled to ask for higher.
Melod, this is what has been sixth schedule, Melod. This is
Correct.
4-1
schedule is a works contract.
Section 4.
Yes.
4-1C, my lords.
4.1C it is.
Yes, all, if after deduction labor, the balance has to be taxed at 14.5%.
Kindly see.
No.
Yes, my lords.
Then
All
again,
works
in addition to this, that amount also.
Once you hold it as a works contract, labor deduction has to be given.
Kindly read section.
Yes.
Read section 4.
Yes.
Liability to tax and rates thereof. 4.1C.
Yes. Along with rule 6.4 also has to be read.
6.4.
Yes, rules are also relevant. 4.1C.
Which I read 6-4.
In respect of transfer of property in goods, whether as goods or in some other form involved in execution of works contract specified in the column 2 of the sixth schedule, subject to section 14-15 of the CST Act at the rate specified and corresponding entries so and so. Now let us go to the rule method.
No, it does not refer to rule at all.
The rules are part of the.
That's all right. Section does not refer to.
We have to determine the total turnover and taxable turnover in each case. So to determine the taxable turnover, we go to the rules.
Which is that rule?
Rule 6.4.
Your lordships have seen the table where it is capped at 15%.
Straight away it is 15.
Yeah, if we don't maintain the books of accounts.
No,
Which table you are reading?
no. Kindly come to schedule 6, item number 23.
We have to determine the taxable turnover. Under works contract, what we have to determine is the taxable turnover, not the total contract, total value. It is true that the 14.5% is right, but then how to determine the value? The lordship will take to rule 6.4.M.
6.4.
Come to it.
Six, 4 and
M and N.
close.
All amounts actually.
Rule,
L and M, sorry. L, 6.4L, 3.2M.
ಯಾವ rules ಅದು?
Just above that L is, first we'll read L.
Rule ಯಾವುದು?
Rule 6.4, my lords.
Of?
KVAT rules.
2005 rules. It is just after the schedules.
2005 rules.
Yes.
Rule 6.
4.
Rule 6.4.
4 ಬರಲ್ಲ.
ಬರುವುದಿಲ್ಲ. Application for partners.
3, I'm sorry, 3, I'm sorry, I am under the CST, the old act. Sorry, 3.2M.
3.2M.
Just about that, let us read L first.
L does not apply.
Determination of turnover.
Yes, ma'am.
The total turnover of a dealer for the purpose of the act shall be the aggregate of A, B, C, D, etc.,
Yes.
etc.
Determination of total turnover. Now let us come to M. my lord. Such amounts calculated at the rate specified in column number 3 of table below towards labor charges and other like charges as incurred in execution of works contract when such charges are not ascertainable from the books of accounts maintained by a dealer.
Your lordships may have to read 2 first, my lord, because that M comes under 2.
2.
3,
L. All amounts.
L comes under 2 only.
Yes.
3, 2 would be
Correct. The taxable turnover shall be determined by following the following deductions from the total turnover. Total turnover ninda
the following amount shall be deducted.
deduct ಮಾಡಬೇಕು. Correct.
So
ಅದರ ಮೇಲೆ ಇಲ್ಲ ನಾವೀಗ.
No.
We are not on that. Deduct ಆಗಿದೆ ಅಂತ assume ಮಾಡಿ ಈಗ.
Deduct ಆಗಿದ್ರೆ balance is taxable.
Balance is taxable at what rate? At rate is 23. So, item 23. ಅಷ್ಟೇ.
Labor deduction ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. Labor deduction ಕೊಟ್ಟಿದ್ದಾರೆ.
It is not his case that deduction have not been given. That is not his case.
Restricted. Your argument is restricted, but you want actual deduction. He wants actual deduction.
Actual deduction he wants. That is not admissible.
No, he says that I have got my books of accounts and it is identifiable.
No, he is on rates. He is on rates of tax.
No.
Huh?
He doesn't.
Deduction as such, man.
Deduction.
Where
He
is
on
that?
deductions only.
25. First question of.
Please do not restrict at 25%. Allow as per the books of accounts.
ಅಂತ ಇವ್ರು ಹೇಳೋದು.
Where in the tribunal's order, my lord, he has produced the books of account or demonstrated that it is higher.
Which deduction is not given? Show that. Where have you take up your ground? What is your ground in relation to rule 3? Torsi.
Tribunal has not gone on that.
Rule 3 ಬಗ್ಗೆ ಎಲ್ಲಿ ಒಂದೊಂದು ವಿಸ್ಪರ್ ಇಲ್ಲ.
ಇಲ್ಲ 25%.
Ground number 10.
Ground 10.
Yes.
Restriction of 25% and not allowing 100% on labor charges. Why you are saying wherein merely by putting the ಎಲ್ಲಿದೆ?
25%.
Rule 3 attract ಆಗುವಂತ fact matrix ಇಲ್ಲ.
No, my lord, he has not quoted the rule, but
ಅದು attract ಆಗುವಂತ fact matrix ಬೇಕಲ್ಲ.
he said, my lord,
25%.
not to restrict at 25% and not allowing 100% of the labor expenses. Which means that 3.2 as per 3.2L, kindly give me deduction as per my books of accounts. Is his contention. Whether the tribunal has examined this issue is what has to be looked into.
Tribunal has not gone into that issue. This was
3 rule 3.2M L.
Yeah.
Attract ಆಗ್ಲಿಕ್ಕೆ ಅಂತ ಏನ್ fact matrix ಇಲ್ಲ.
The fact that he says that give me 100% of my labor expenses is nothing but asking to apply rule 3.2L. You cannot have quoted the rule, but doesn't.
Quote ಮಾಡೋದು ಬೇಡ. Rule attract ಆಗ್ಲಿಕ್ಕೆ ಬೇಕಾಗೋ fact matrix ಅನ್ನು quote ಮಾಡ್ಬೇಕು.
Facts, they have to place no doubt, but they have claimed, they have raised the ground.
ನೋಡ್ಕೊಂಡು ಹೇಳ್ರಿ. ನೋಟಿಸ್ ತೊಗೊಳ್ರಿ.
noticed all of it.
ಆಗಿದೆ.
ಆಗಿದೆ sir.
Notice ಆಗಿದೆ. ನೋಡ್ಕೊಂಡು ಒಂದ್ಸರಿ ನೋಡ್ಕೊಂಬರ್ರಿ. ನಾವು ನೋಡ್ಕೊಂಬರ್ತೀವಿ. ಇದ್ರ ಮೇಲೆ ಹೊಸದ್ ನಮಗೆ.
Tribunal has not gone into that issue.
There is nothing placed before the tribunal letter. Yes, it's not.
What has happened, my lord? Pursuant to the order of joint commissioner, it was remanded back to the assessing officer. Assessing officer simply did 25%. That just allowed 25% of the labor charges as expenses. That order was appealed before the joint commissioner. Joint commissioner said that you need not appeal on this order. You have to file an appeal before the previously passed Joint Commissioner's order. And the very same very same order was reiterated by the tribunal also.
ಅದ್ ನಾವು ಓದ್ಕೊಂಬರ್ತೇವೆ. ಅದು ಒಂದ್ ಕೇಸ್ನಲ್ಲಿ ಮಾಡಿ ಮತ್ತೆಲ್ಲ ಅದ ಕೇಸ್ ಇದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು ಹೋಗ್ತೀವಿ. ಇದು ಎದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು ಆದಿತ್ಯ? ವೈ ಹೋಗಿ ಒಂದು
Para 70.
17.
Initially, what happened, Malad, in one of the cases, the state of AP versus Pune elevator, in one of the courts, Supreme Court, they held that it is a sale, not a works contract. But it is, later on, it was reversed by this.
Coming back to the cone elevators, it is perceivable that. Someone's obligation to do the civil inspection and time should be completed. Take away the major component sector, the skill. It's a composite contract.
Once it is composite. Once it is composite, I have the benefit of the section.
The rate of tax is not disputed. What he's saying is that I should get.
Discounts, deductions have not been given on that. What deduction has not been given? The question of deduction will not arise once it is a composite contract.
No. Your lordship will go back to the judgment, state of AP versus Pune elevators. It has been held that no deduction is given. Because it is a sale, implicit. But later on, the full bench said that it is a works contract. Once it is held to be works contract, 6(4)L and 3(2)L and M will apply. And as your lordship know that every service, every works contract involves a labor portion, that is service portion, and transfer of property. So the service portion, the service tax is applicable earlier. Now it is GST. So service tax was payable, and so far as the sale of goods is concerned, VAT was applicable. So to determine the taxable turnover, we exclude the labor expense.
My only difficulty is none of this discussion finds place anywhere in the trail leading to the Honorable High Court. Appears to be being raised. No.
All these facts are not in your petition at all, anta.
So
orders ಬೇಕಲ್ಲ ಎಲ್ಲಾದ್ರೂ.
Let him examine what is the actual JC appeal. I believe he says that JC appeal has remanded the matter.
Please.
To re-examine. So once the matter has been remanded for re-examination, I am not sure why they came to the tribunal.
That same order of the tribunal is challenged here.
No, it was revenue which came to the tribunal. No,
We
you
are-
only.
we are-
Why?
He had, the matter was remanded back to the assessing officer. He has restricted the 25%
Yes.
labor charges. Against the levy of restricting the order of 25%, we appealed to the joint commissioner. Joint commissioner simply held that you should have appealed against the order of the earlier erstwhile order passed by the joint commissioner, and not against the order of to the tribunal passed by the erstwhile joint commissioner, not against the AO order. And the same was reiterated by the tribunal also.
So then what has happened, somewhere they went back to the assessing officer. Assessing officer again held it 25%.
25%.
So they-
Because he had not challenged another joint commissioner's order.
Why he should challenge? Because JC had remanded.
Remanded back.
And what happened? He came back to the JC appeal. JC appeal again said that 25% only I will give. No, he said that the earlier order, you are not challenged it.
In substance, my lord, if that is the case, whether it is open for him to have his books of accounts examined by this honorable court. Of course, it's a plenary court with constitutional powers is one aspect. But where is the occasion for when there is nothing in the impugned order for this honorable court in a petition involving
No,
revision?
it's a case of remand. It's now case, remand is there. Let remand authority decide all these aspects.
Yes.
First observation ಮೇಲೆ ಮುಗಿಸ್ಬೋಣ.
Yes.
ಮಾಡ್ಬೋದಾ?
Yes, this court cannot sit in looking into the.
That's
account.
what. That's what. So we'll make it a consensual order.
My lords,
Both the sides agree.
my lords.
ಯಾರು my lord ಅಂತ. both the sides agree that all questions that are raised in this petition be treated in by the assessing authority, no? Assessing authority in a time-bound manner and in accordance with law. First off, ordered accordingly and petition is disposed of, keeping open all contentions of the parties. ಏನ್ ಮಾಡ್ಬೋದು ತಿರುಮಲೇಶ್, ಬೇರೆ ಏನಾರ ಹೇಳ್ಬೇಕಾ?
Remand it back to the assessing authority to examine the.
Accordingly, the matter is remanded to the
claim of
original
deduction.
authority.
To examine the
To
claim.
examine the claim of deduction.
Original authority to examine claim of the assessee. Deduction, claim of the assessee for deductions in terms of rule 3 to F and M, L and M, 3 to L and M.
If applicable, your lordship. If applicable.
If applicable.
Yeah.
Okay. All right, I'll structure that order that way.
Deeply appreciated.
Good, officer. We'll come back in a few minutes, of seconds. Okay, one minute.
With your lordship's can, next matter, my lord, another two connected matters are there, my lord. It may be clubbed, my lord. 655 and 650.
Call along with Madaka.
Call along with.
Call along. Okay.
I'll give the number. Six 55 and 656. 655 and 656. Sir. Sir. ಸರ್ ಒಂದು ಲಿಸ್ಟ್ ಕೂಡ ಕೇಳಿದ್ರಲ್ಲ ಸಾಹೇಬ್, ಅದು ರಿಟ್ ಅಪೀಲ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಒನ್ ಡೇ ಅಲ್ಲಿ ಆಗಲ್ಲ, ನಾಳೆ ಅದನ್ನ ಕೆಳಗಡೆ. ಆಯ್ತು.
46 ಏನು ಟೈಮ್ ತಗೊಂಡಿಲ್ಲಲ್ಲ, ಲಾಸ್ಟ್ ಮಿನಿಟ್. ಶಿವರಾಮ್ ಕಾನತ್ಲೆ ಅವ್ರದ್ದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ, ಅದಕ್ಕೆ
ಬೆಳಿಗ್ಗೆನೆ ತಗೊಂಡ್ರು.
7th ಆಯ್ತು, 7th ನಾ ಅವ್ರಿಗಾರನೇ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ. ಥ್ಯಾಂಕ್ ಯು.
ಕೆಲವೊಂದು ಮಧ್ಯೆ ತುಂಬಾ ಅರ್ಜನ್ ಆಗೋದು. ಈಗ ಎರಡು ಅದು ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ.
Three.
Here,
Ah.
I'll just point out certain facts, my lord, and then could be closed against me itself. Now, the question raised is whether the ITAT is correct in not considering the fact that the interest income received from cooperative banks has to be disallowed in view of the binding decision of Totgar's in 395/611. The first question is correct in considering the interest received from investment made in SCDCC Bank as operational income. So, lots of as per RBI guidelines, if a cooperative society bank deposits certain portion of the amount, 25% in other, they have to invest. And interest earned out of it is considered as operational income. And it is also exempt.
Interest
Earned out of legal compulsion.
Made by the cooperative bank in some other bank.
In other bank deposited out of legal compulsion.
Legal compulsions. For example.
For RBI guidelines. To your liquidity funds should be deposited in another cooperative bank.
What the courts have said?
Courts have said that that is not liable to tax. It is part of the deduction eligible under ATP.
ATP?
Yes.
I remember having decided one such matter.
Yes. Quite possible. And
no, I decided it in Bangalore.
Essentially says deduction to be allowed in the case of an SSC amounts to the members during the course of his
business
lending of, the specific word is
ATP 2A1.
Who is in the business of providing credit facilities to the member.
That is credit cooperative society alone.
So
not others.
the thing is, yes, it should be a society providing credit facilities to its member, and that amount should have been lent during the course of its business of lending money. Now, my lord, the issue arises, what happens to the idle money which is kept for lending? RBI has issued some guidelines for the purpose of liquidity, maintaining the liquidity, that 100% cannot be lent. A certain amount of money
has to be deposited. Whether
that is
interest earned on that deposit is taxable or not is the issue.
So whether it is that amount, that income is earned in the business of during the course of lending amount.
Actually, it is not relation to lending business at all anta one argument ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಈ amount ಇಡೋದು ಸಹಿತ ನಮ್ಮ business ದ part ಇದು. We do it because there is compulsion of law. Therefore, it should be treated as business antana your argument.
Yes.
How courts have considered this aspect?
My lord, the amount which has been, which they were forced to invest it, should be treated as the income
Business.
earned.
It appears that way.
Yes.
How courts have answered this question?
Courts have answered saying that Totgar's case, that any amount invested out of compulsion
of law,
it is part of the.
It should be treated as part of the business only.
Part of the business income and therefore eligible for deduction.
Because you had no opportunity to trade with that money at all. Because as a matter of compulsion, you have parked that money in some entity and that earns some income by way of interest. That interest is to be exempted from income tax because you should treat it as part of the daily course of business.
At the same time, if a society, a bank, a cooperative society bank has got more than that amount and they invest much more than that required because of interest earning income, that income will not be considered as an operational business. Operational income.
In other words, suppose 1 CR ಇದೆ ನಿಮ್ಮ ಹತ್ರ. ನೀವು ಒಂದು 30 CR ಲೆಂಡ್ ಮಾಡಿಬಿಡ್ತೀರಿ ನಿಮ್ಮ ಬಿಸ್ನೆಸ್ನಾಗ. ಇನ್ನೊಂದು 30-40 CR ಲೆಂಡ್ ಮಾಡಲ್ಲ, ಹಂಗೆ ಉಳಿದಿದೆ. In addition to that, one 40 CR is pending, kept by way of compulsion. In such an event, you will not earn it.
That will not be part of the business income.
Because you have this money itself is with you.
Yes.
Therefore, it is not part of lending. Anta.
Now, the fact finding is that by the tribunal is that from the above, it is obvious that the assessee's entire investment of 42 crores as on 31/3/2018 in SCC DCC Bank is a statutory required investment and not made out of choice to earn extra profit.
You had no choice at all.
No choice. Total investments required to be made as per the act is 90 crores.
And you had invested
42 crores.
less than that.
Less than that. Whereas the actual investment is 42.98 crores. Hence, interest income of 3 crore 53 lakh 68,000 is chargeable under the head profits and gains of business or profession. Therefore, the same is eligible for deduction under 80P.
You want to challenge this? It appears to be very sensible.
It is quite right.
A ruling ilva.
Ruling is there, my lord, 395 ITR, or rather, I don't know whether they have the ITR. I have not brought the ITR. Otherwise, it can be called tomorrow.
ಮುಗಿಸ್ಬಿಡ್ತೀವಿ ಮತ್ತೆ ಟೊಮರ ಏನ್ರಿ? ಅಲ್ಲಿ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ, ಎಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಆಫ್ ದಿ ಟ್ರೈಬ್ಯುನಲ್ ಯಾವ ಪೇಜ್ ನಲ್ಲಿ ಓದಿದ್ ನೀವು?
Page 21. Fact finding is at page 21.
Para 13, 12.
Para 12. At page 18. The AO and in the middle, my lords, 1, 2, 3, 4, 5, 6, 7, 8, 9 line, page 18. AO also issued show cause notice.
Directing the assessee to explain why the said interest income should not be assessed under the head income from
This-
other sources.
In the next line, in the said show cause notice, the AO has referred to the judgment of the Honorable Apex Court in Todgar Cooperative Society, Sales Society versus ITO reported in 322/283, as well as judgment of the Honorable Jurisdictional High Court in the case of the PCIT versus to the Todgar in 395/711. A copy of the show cause notice, notice issued by the AO has been placed on record at from pages of 90 to 101 of the paper book by the.
So what they say is not out of choice.
Yeah.
It was a compulsory statutory requirement.
Yes.
ಅಂತ in this context assessment it is the part of the operational income ಆಗ್ತದೆ. Same has to be assessed under the head income from business or profession, which would entail the benefit of deduction under 80P2AI.
Yes. One.
ಅಷ್ಟೇ ಕೇಸ್ ಇದೆ.
ಅಷ್ಟೇ.
ಕರೆಕ್ಟ್ ಇದೆ ಇದು.
That's all.
Reasoning correct ಇದೆ. On what ground you want to falter this?
Our argument is that whether you do it out of compulsion or otherwise, both are not eligible.
No, it's only if it is in the course of business, you are entitled to exemption. But
Yes.
provided the amount which I keep there, I would have used it in my course of business only. That option is lacking anta reasoning ಅವ್ರದ್ದು. ಹಂಗಾಗಿ whatever you have kept because of the compulsive law, that amount is not available to me, which otherwise would have traded.
What we are trying to say is, we are also relying on the same judgment to say that idle money kept.
Idle money ಅಲ್ಲೇ ಅಲ್ಲದು.
ಅಲ್ಲ ಇದು.
No, it's not idle money. The short question, ಕೂತ್ಕೊಳ್ಳಿ. arising in this appeal is as to taxability of amount of the credit cooperative society parked in a bank as a matter of legal requirement away from,
Lord, may I just read that section, my lord, that may have to be quoted, ATP two.
ATP to AI.
A1.
A1.
A1. Sums referred to in subsection 1 shall be the following, namely, A. In the case of a cooperative society engaged in 1. Carrying on the business of banking or providing credit facilities to its members. So whether the
Not to
interest,
its members anta ನೀವು ಹೇಳೋದು.
whether it will be treated as whether the compulsive, whether the amount which has earned on as interest from the compulsory deposits will be taken as income from, my lord, carrying on the business of banking or providing credit facilities to its members. That is a phrase. ATP to A1.
ನೋಡಮ್ಮ, refer to
In
AT capital P
bracket
ಆಮೇಲೆ
2
English 2 small a small I
separate 2
ಎಲ್ಲ ಬೇರೆ
A1.
ಬೇರೆ of the IT Act. ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ರೆಫರ್ ಮಾಡಿದ್ದು?
Coopgars Cooperative Society reported in 395 ITR 611.
395 TR 711 ನಾ?
611.
ಯಾವ್ದದು, ಎಲ್ಲಿದೆ ಅದು? ಎಷ್ಟು ಮಜಾ ಇದೆ ಕ್ವೆಶ್ಚನ್.
Questions of law ಅಲ್ಲಿದೆ. ಅದು ಅವರು ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ 711 ಅಂತ ಬರ್ತಾರೆ. It is now one same.
711 ಅಲ್ಲ ಅದು.
ಅಲ್ಲ.
395 TR
ITR 611.
ಇದು TR ಅಂತ ಯಾವ್ದೋ ಇದೆ. ಇದು 395
ಐ ಬಿಟ್ಟೋಗಿದೆ.
ಓ ಬಿಟ್ಟು ಹೋಗಿದಾ? 395 ITR 611 ಆ ಹಿಂದಿನ ಪೇಜ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ. ನೋಡಮ್ಮ, ರೆಫರ್ ಟು 395 ITR 611 dismissed, agreeing with the reasoning of the tribunal. ಎಷ್ಟು ಹೊಸ ಹೊಸ ಕ್ವಶನ್ಸ್, ವೆರಿ ವೆರಿ ಡಿಫರೆಂಟ್ ಕ್ವಶನ್ಸ್. Yes, we uphold the reasoning of the tribunal. Yes.
Therefore, questions of law doesn't arise.
Will not arise. Registry to send a copy of this. In view of the settled position, the question of law would not arise at all. Okay. Even otherwise, question has to be answered against the revenue. Okay. As has been done by the tribunal. Yes.
Lord, we have made our attempt, my lord, and we have referred to certain books also. Of course, we could not able to identify appropriate portion in the book which is directly on the point involved in this particular dispute, my lord.
Where discharge is claimed by the surety.
Yes, my lord.
On the ground that there is variation of terms of contract.
Yes, my lord.
Without his knowledge and participation.
Yes, my lord.
Whether discharge is absolute or it is pro tanto discharge to the extent that the variation takes place.
My lord, there is the judgment of the Privy Council, my lord, which was referred to on last occasion of the year 1935. Subsequent to that,
Jinnah had argued.
yes, my lord. Yes, my lord. There is one particular law which has been developed, my lord. Section 133 and subsequent provisions which is available in the Indian Contract Act with reference to guarantee, which has been considered in the light of section 62 of the Indian Contract Act, whether it amounts to novation and under what circumstances there is a novation that has been considered by the division bench of Delhi High Court, my lord. If at all there is a one particular contract.
If novatio takes place, then he is discharged.
Yes, my lord. In this particular case, my lord, this is the similar type of a circumstances exist, my lord. The earlier promissory note, there is a fresh promissory note which has been replaced, my lord. Earlier, there was a letter of guarantee, fresh letter of guarantee has been executed and earlier letter of guarantee has been replaced. Then, my lord, there is a one particular memorandum of deposit of title document that has been replaced with the another memorandum of deposit of title documents. So virtually what was the earlier contract that has
That
been
has gone and new contract
Yes,
has
ma'am.
come. That is the
So-
idea of no issue.
Yes, my lord. So 133 has been considered in the light of section 62, my lord. And then, but that particular judgment under consideration before the Supreme Court, my lord. The bank has preferred it, my lord.
The one which you cited in
Yes,
your favor.
which I want to cite today, my lord. So that is under consideration before the Supreme Court, my lord.
That has gone against the bank.
Yes, my lord. It has gone against the bank, my lord.
True.
My lord, he may not be aware, my lord, because I have to provide the copy to him also. It is of the year 2019. It has been decided in the year 2019, my lord. Then, my lord, my learned friend was citing state of Rajasthan, my lord. That was the judgment of judgment which has been rendered by the Justice Pardiwala, my lord. And in that particular judgment, whether the jurisdiction is ousted or not was the question, my lord. And the court has, Supreme Court once again has held that the jurisdiction is not ousted, but strictly the provision has to be, yes, my lord. The provisions of section 9 has to be strictly construed. That is what has been. And it cannot be readily inferred that the jurisdiction is available. The scope is available, but it is a narrow scope. That is what has been.
That was after referring to Dhulabai.
Dhulabai also. And Nahar also has been referred to. And more particularly, my lord, the tribunal is not a court, also reiterated in that judgment. And tribunal within the parameters of the provisions of the act, that is Survey C as well as RDBI Act, it has to decide. Beyond that, it cannot decide. That is what has been observed, my lord.
Why that question arose?
My lord, in that
Tribunal acts under this act.
My lord, the question was that, my lord, two brothers, my lord, excluding the sister-in-law, who has the sister-in-law who had lost her husband, who is also the co-owner of the property, executed a sale deed, my lord. Then the purchaser executed a mortgage deed in favor of the bank, my lord. Then that particular sister-in-law filed a suit for declaration that sale deed is bad on her portion of the share, as well as the declare that mortgage is not binding on her. So those declaration was sought. Then, my lord, rejection of plaint was sought for by the bank. That application was allowed. Then appeal was filed, my lord. Appeal was allowed by the MP High Court, my lord. Against that, SLP was preferred before the Supreme Court. The Supreme Court said that, my lord, the civil court has the jurisdiction in those circumstances because that particular declaration only civil court can grant. That is what the Supreme Court has held in the recent judgment, my lord, that is pronounced only on 9th January 2025. Mardia Chemicals has been considered, my lord. Nahar has been considered. Dhulabai has been considered. Hiralal also has been considered. And this is what the Supreme Court has held, my
lord. What is your first proposition of law?
My lord, my first proposition of law is that, my lord, if subsequent contract between the borrower and the banker with regard to the enhanced credit facility, if it substitutes the earlier contract and results into a novation, the liability of guarantee is completely discharged. If it is a fabricated document, the subsequent contract is a fabricated the document. It bears his signature, but it is not his signature.
How bank should decide all that? How tribunal will decide whether his signature or not, etc.
Yes, ma'am.
Therefore, you want to say it should go to the civil court.
Yes, yes.
The tribunal has no power to assess, take expertise of forensic laboratory and arrive at a decision.
It's a summary proceedings, my lord.
In every case, they will say this is not my signature.
Only, my lord, if I have prima facie made out a case and it is not a just mere statement of fraud. If I have laid the foundation for that, in such an event, if I show that, yes, the fraud has been committed, and in such circumstances, my lord, the civil court gets the jurisdiction to a limited extent.
What is the civil court stays now?
The civil court, my evidence has started, my lord. I have adduced my evidence. Now they have to cross-examine my witness.
In your RFA, there is no stay also. One appeal.
RFA, I succeeded, my lord. Rejection of plaint was favored and the plaint was rejected by
That is at the
this.
context of surfacing.
Then, my lord, I preferred an appeal before this honorable court. This honorable court said that civil court has the jurisdiction. This question has to be thrashed out by the civil court only between the same parties. And that particular order has attained the finality also.
He has not challenged that.
He has not challenged that.
But we accepted and we pursued the matter before the DRT. And DRT, my lord, after hearing the matter, my lord, posted a matter for argument, orders.
Now, I'm just thinking, suppose if we direct the civil court to complete the trial within 4 weeks.
My lord, the reason is this. I'll just point out, my lord. First and foremost, my lord, in respect of no issue also, my lord, it can be urged before the DRT because my suit is, my lord, 2015. The matter pending before the civil court, my lord, it is in the year of 2019. So, my lord, pursuant to, my lord, my surface action initiated. My lord, before the civil court, in fact, my lord, I am also party, my lord, that is only at the context of surface. My lord, Madia Chemicals, my lord, in fact, the civil court, my lord, at the instance of Madia Chemicals, where, my lord, they don't have a remedy when, my lord, except, my lord, under section 17. Therefore, my lord, this honorable court said any fraud, element of fraud, any allegation, they have to go to civil court in respect of surface. My lord, here, the DRT is a complete court. My lord, I'll just point out, my lord, the order passed by the DRT. The two orders held before this honorable court, one is DRT and DRAT. Lord, I'll just point out my lord permits. My lord, kindly come to my lord page number 170.
No facts, foundational facts, Eli.
My lord, 2015, the borrower availed a loan.
2015.
Then just 2011, my lord. The borrower availed a loan. The present petitioner is a guarantor. He offered his property as a collateral security. And my lord,
petitioner is a guarantor.
Guarantor. And he's offered the present scheduled property, my lord, as an offered.
So he is the mortgager.
Mortgager. It is not in dispute. And he is also offered a guarantee and he agreed for the rate of interest. The petition on 25/7/2011, my lord, the petitioner executed a memorandum of deposit title deeds in favor. That is, my lord, document number 1, page number 23 in my statement of objection, my lord.
This loan was availed in which year?
2000, my lord, 11.
Sorry, it was in the year 2010.
10,
Yes, I'm sorry, 2010.
2010. Okay.
I'm so sorry, 2010, my lord. And 2011, on 25/7/2011, the registered mortgage deed executed in favor of the bank. My lord, I'll just point out that one document. 25/7/2011. My lord, may kindly come to my lord page number 23, because it's a one document, registered document, my lord, they cannot deny. That is the reason, my lord, they're not disputing this document.
It's registered.
Registered document.
Okay, next.
It is not in dispute so far. My lord, later enhancement taken place on, my lord, 7/8/2012 from initially 7.5 crore. The mortgage is created for 7.5 crore. From 7.5 crore to 10 crore, the enhancement taken place. And wherein the present petition also, my lord, extend his guarantee for that.
Adu register ಆಗಿದೆಯಾ?
Guarantee registration agala. That is the one, it can be easily, my lord, deny that document. That is a difficulty which bank are facing.
Enhancement to?
My lord, from 7.5 crore to 10 crore. And another 4 crore rupees. Total, my lord, put together 14 crore agate. Adi guarantee kottidare. That is at, my lord, page number 33. That very same petitioner extend his guarantee. My lord, after a period of 4 years, that account became NPA. My lord, kindly see, my lord, the original documents with me. 2013, when enhancement, 2014, that dated, my lord.
Enhancement happened when?
My lord, on 27, 1 minute, my lord, 7/8/2012. 9/8 ಗೆ guarantee execute ಮಾಡ್ಕೊಡ್ತಾರೆ.
Okay.
My lord, on 29/11/2014, after my lord almost 2.5 years, that account become NPA. My lord, they are not added in terms of my lord.
NPA ಯಾವಾಗಾತು?
28/11/14. My lord, on 30th/1/2015, the bank filed the original application before the DRT at Bangalore.
Filed on?
My lord, 31/15. 31/15.
For rupees?
For rupees, my lord, 16 crore. 16 crore 30,77,966.
16 crore 30 lakh?
77,966. Wherein, my lord, petitioner arrayed as my lord defend number 9 in the said suit. Said original application filed by me. In the meantime, my lord, that has been assigned from my lord Lakshmi Vilas Bank to me, that is Reliance CRC, that is permissible under law. And we filed a substituent, and my lord, later, my lord, the petitioner filed a return statement before the DRT. Before the DRT, that is at my lord page number.
On
my lord,
25/1/2019.
25/1/2019. That's return statement, my lord, I may permitted to point out, wherein they admitted their debt. I'll just, my lord, point out the return statement for a moment.
25/1?
Return statement. My lord, page, it is at page number 75. 27/3/2019, alva? 27/3/2019, my lord. That is at page 70.
25/1 ಅಲ್ವಾ?
27/3/2019.
File ಮಾಡಿದ್ದಾ?
Yes. That is at my lord page number 75. Wherein, my lord, they admitted the mortgage for at rupees 7.5 crore rupees.
First one.
First, my lord, that is at page number 77.
ಅಲ್ಲ, first one.
First one, ಹೌದು. ಅದೇ admit ಮಾಡ್ಕೊಳ್ತಾರೆ.
Para
9, page number 77 of the petition. The defend number 9 is the owner of the property, bearing survey number so and so. ಕೆಳಗಡೆ ಬರ್ತಾರೆ property ಆದ್ಮೇಲೆ. Defend number 9 is direct defend number 1 complete, defend number 1 wife of the so and so.
Para 7 ನಾ?
14 ಸ್ವಾಮಿ. 9, 14, 15. 14ರಲ್ಲಿ on 25/7/2011, the defend number 9 executed a registered memorandum of depository title in favor of the applicant bank. And mortgage schedule pay. It is not in dispute.
Yes. Subsequently change ಆಗಿದ್ದೇನು? ಯಾವುದು fraud ಆಗಿದೆ ಅಂತ?
Fraud ಆಗಿದೆ later 2012 document ಅವರು ಹೇಳಿ, because it's not a registered document. 2011 document is a registered mortgage deed. My lord, what will happen in a bank? Till today, my lord, the registration of mortgage is not mandatory in the bank, but which, my lord, in this case, what had initially the mortgage was registered document. Second one, my lord, only we have taken a guarantee and we have taken a letter of extension from them, and my lord, we release a fund in favor of, my lord, the petitioner, borrower and petitioner, at the instance of petitioner. My lord, that is in dispute now. My lord, later, my lord, we initiate the action under SURFACE Act. My lord, that
is enhanced to 10 crore.
Yes, ma'am.
ಇದು ಮೊದಲಿಂದ ಇನ್ಸೆಪ್ಷನ್ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿ ಹೋಗ್ಬಿಡ್ತದ?
Yes, my lord. That is what the division bench of the Delhi High Court, referring to the Privy Council judgment, has held so far. Held like that, my lord. They have taken note of section 62 of the Indian Evidence Act, And not in all the cases, if there is a novation, in such circumstances, it would happen, my lord. That is what it has been held.
ಅದು ನವಶ್ಯ ಆಗ್ತದ ಇದು?
Yes, my lord. In this
Where
particular
only
case,
amount is enhanced.
my lord, I will explain, my lord. The first, my lord, it was in the year 2000. I will not, in the year 2010, my lord, it was 1.3 crores and 3 crores. One term loan was 1.3 crores, my lord.
Correct.
And then the open cash credit limit of rupees 3 crores, my lord. I was not at all a party. I was not a guarantor for that particular initial transaction, my lord. Then, my lord, in the month of July 2011, my lord.
25/7/2011.
Yes, my lord.
You mortgaged.
Yes, my lord.
And you secured repayment
Yes,
by
ma'am.
virtue of this property.
Yes, my lord. Then I also.
That was 7.5 crore.
Yes, ma'am. 7.5
Which included earlier money also.
Yes, ma'am.
Yes.
Then, my lord, after that, my lord, on 2 occasions, there is an increase in credit facility and also fresh documents have been executed. That was in 6/11/2012, my lord.
First documents for what money?
For the increased money, my lord, that is,
Increased money.
that was for the 8.5 crores, my lord.
That was about 10 crore.
My instruction is that, my lord, 7.5 plus 2 crores, that comes to around 9.5 crores, my lord. With interest, it is 10 crores rupees, what is mentioned in the document. They did not stop here, my lord. Then, my lord, next there is an increase in the year 2014 to the extent of 17 crore 30 lakh rupees.
One more enhancement.
Yes, my lord. One more enhancement was in the year 2014, my lord.
₹2?
17 crore 30 lakh rupees, my lord. For these two increase in the facility, my lord, I am not a party, I am not a guarantor. Then, my lord, I want to highlight one aspect, my lord. Original mortgage deed which I had executed.
For 9 point, all right, 10 ante idಕೊಳ್ಳಿ, 10 CR.
Yes, my lord.
You are a party, you are executed.
7.5, yes, my lord, I am a party. That was on 25th.
First enhancement also.
No, yes, my lord, because first enhance merged with the second enhancement, I become liable because increased amount I stood as guarantor.
Correct.
As well as I executed a mortgage.
Correct.
So that particular original amount merged with the second enhancement.
That will be?
Yes, my lord, 7.5, my lord.
Okay.
And in my mortgage deed, I have specifically mentioned 7.5. In my revival letter, letter of guarantee, promissory note, every document 7.5 which has been mentioned, my lord.
Okay.
Then this particular mortgage deed is a registered mortgage deed, my lord.
Yes.
The next mortgage deed, which was executed on 6/11/2012.
6/11/2012.
In 2011, my lord, I was a party. The second enhancement was in the year 2012, my lord.
That was 7/8/2012.
Yes, my lord. So there is on 6/11/2012, my lord, mortgage deed was executed.
The second mortgage.
Yes, my lord. The second mortgage. This particular second mortgage.
6/12?
6/11/2012, my lord.
You admit this?
No, my lord. It bears, it is not a registered document. My signature has been forged in this particular document. It is not, this particular document has been considered by the police authorities. And they have compared this signature with that of the registered document. And then they have come to a conclusion that these are all the document which is fabricated. On the same day, my lord, the day when this particular mortgage deed, unregistered mortgage deed was executed, the principal borrower executes a registered mortgage deed insofar as his property is concerned. On the same day.
No, assuming the subsequent document is void.
Yes, my lord.
Your liability to pay that 10 crore remains intact.
No, my lord, what happens is that, my lord,
And that will discharge is your contention.
7.5 has merged with the enhanced amount of 10 crore rupees.
That's what
Yes.
include the 10 crore, that
Yes.
7.5 that becomes to 9.5 plus
Yes, ma'am.
50 lakhs interest
Yes,
together, that becomes 10 CR.
Yes, my lord.
For that only you had agreed for that.
My lord, what happens is that, my lord, once that particular enhanced credit facility is given, fresh promissory note has been executed, my lord.
Correct.
And that has replaced the earlier promissory note. Fresh letter of guarantee has been issued. That has replaced the earlier letter of guarantee. Then revival letter has been issued. That revival letter, my lord, I have not executed. And that particular debt also becomes time barred insofar as I am concerned. Because all the subsequent documents are tainted documents.
So therefore, even earlier money also you need
Yes,
not
my
pay.
lord, because
That
there is a
also-
novation. There is a novation. Novation as well as limitation, my lord. It is not only on the novation, on the question of limitation also, insofar as I am concerned.
Well, I'll just answer, my lord, in respect of novation.
I request my lords to kindly see 3 documents, my lord. I will not request more than 3 documents, my lord. I request my lords to kindly take, my lord. This is part of the plaint, my lord. The plaint and documents I am producing, my lord. The page number 98, my lord. Document number 14, my lord.
Consent letter for continuance of
Yes, ma'am.
guarantee.
Yes, my lord. The amount mentioned here is, my lord, 18 crore rupees as on 9th December 2013.
This itself is forged document.
Yes, my lord. My signature is a forged signature, my lord. The amount is for 18 crores.
No, that we understand.
I request my lord.
This is being adjudicated in the civil court, we can understand. But what about your liability which you had undertaken? Even that also will
Yes,
go.
my lord. Yes, my lord. The kindly
authority.
Yes. Yes.
This consent letter is given by whom? Stated to have been given by you.
Yes, my lord.
When you have not.
Yes, my lord. I have not.
Correct. Who is the guilty party?
The collusion, it is a product of collusion between the officials of bank as well as the principal borrower. That is what has been observed by the police authorities also.
Police authority, my lord, so far, my lord, none of the documents before this honorable court, or I am also not aware. My lord, he would have, my lord, any documents before, my lord, he would have produced before this honorable court. My lord, nothing, my lord, placed before this
My
honorable.
lord, it is 8-volume documents, my lord. Blue corner notice has been issued against that particular person. I can produce it, my lord. It will only
On instruction, my
addition
lord,
of
I
the
may make a
documents.
submissions, my lord. None of my officers, my lord, so far, my lord, either, my lord, any charge sheet or any, my lord, not in, my lord, investigation.
Our ಮೇಲೆ complaint
ಏನು ಇಲ್ಲ.
ಇದೆಯಾ? Bank officials.
My lord, they have observed that the police, the bank officials are involved and further investigation against the bank officials has to be conducted. And the bank has not cooperated providing the documents. This is the observation which has been made.
ಬ್ಯಾಂಕ್ ಹೆಂಗೆ ಇದನ್ನ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೌ ಬ್ಯಾಂಕ್ ವಿಲ್ ಬಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ದಟ್ ಬ್ಯಾಂಕ್ ಆಫೀಷಿಯಲ್ಸ್ ಹೌ ದೇ ಆರ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ನಂಬರ್ 1
Yes.
That discharge
Yes, ma'am.
of function will be outside the assigned duties of the bank official.
No, my lord. It has entered the premises of the bank and bank has accepted it and acted upon it. And mortgage deed, my lord. Mortgage deed in every mortgage deed is a registered mortgage deed. Insofar as the transactions subsequent to 2012, 13 and 14, all are unregistered documents. And with respect of principal borrower, they have gone to the sub-register office and it is registered. Whereas with respect of us, it is with respect of me, it is not registered document.
Allah, extension of amount.
Yes, ma'am.
Enhancement of amount.
Yes, ma'am.
That does not require registration.
No, my lord.
No, my lord, as per there is no law as such that it should be required to be registered. But the RBI says that whenever the high profile amount is involved, more particularly 1 crore is involved, such document should be registered, my lord. And it is a guidelines of the RBI, my lord. There is no statutory requirement.
ಅದೆಲ್ಲಿದೆ
Yes, ma'am.
RBI ಇದು
My lord, I request my lords to kindly take para 22, my lord, where the discussion starts with respect of section 62, my lord. If my lords permits, I request my lords to kindly take digital page number 8, my lord, above para 10, my lord. Digital page number 8.
Mr. Shankar may not wait. It will take some time.
Serial number 36.
Ah.
I filed another additional pure question of law. It may be taken about 2 weeks.
ನೋಡಿ ಮಾರ್ನಿಂಗ್ ಕೇಳಿದ್ರು ಅವರು ನಾವೇನೋ ರೀಚ್ ಆಗಲ್ಲ ಅನ್ಕೊಂಡು ಓಕೆ
No problem.
2 weeks.
Deeply applied.
My lord, the second question, the issue which was framed by the tribunal, my lord, it reads like this, my lord. Whether the agreements with D2 and D3.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು?
Sorry, my lord. Above para 10, my lord. There is one hanging paragraph is there, my lord. Above para 10, my lord. The numerical number 2, my lord. That was the issue framed by the DRT, my lord.
Whether the agreements with D2 and D3.
After 21/7/1995, discharge
D4, D5 and D6.
That was the question, my lord. The 21/7 to 1995 was a subsequent agreement, my lord, with the bank. The fraud was not involved in that particular case, my lord. It was not a case of fraud. Para 22, my lord. Para 22, I will read, my lord. The DRT's view, in facts and circumstances was that new management had taken over the respond number 3 company, that is respond number 5 and 6, and they had executed documents for enhancement of their limits, and accordingly they had given the collateral security of the property of respond number 7. On that basis, new agreement of loan was entered into by the respondent bank with respondent number 3 company through its new set of directors, namely so-and-so and so-and-so. And apart from their personal guarantee, collateral security of the adequate worth was also given by the respondent number 7. Hence, the earlier agreement of personal guarantee as well as earlier collateral security of IDBI bonds given by so-and-so stood discharged. Feeling aggrieved by the bank, preferred an appeal before the DRAT, which had reversed the said finding and had reached to the finding that present petitioner as well as the respondent number 4, who were respondent number 1 and 3 in appeal before the DRAT, were liable for the debts of the bank on the basis of the earlier set of personal guarantee executed by them and collateral security of IDBI bonds given by the so-and-so. It is interesting to note that as far as guarantee bonds dated so-and-so set up by the bank are concerned, DRAT has agreed with the conclusion arrived at by the DRT, however, on a different grounds, and has also returned the finding that there was no occasion for these persons to execute the said guarantee bonds on 22nd July 1995. This finding has been challenged by the bank in writ petition filed by it. This case squarely falls under section 62 of Indian Contract Act, which is reproduced here under. I will not read that particular portion, my lord. Then para 25, my lord.
The present case.
In the present case, there is no denial of the fact that initially loan was taken by the respondent 3 company on the basis of documents executed by the petitioners and respondent number 4. As the petitioner number 1 and respondent number 4 are concerned, they were also directors. Petitioner 2 is the wife of the petitioner number 1, and she stood as surety. The collateral security was of the Indian development bonds pledged by the respondent number 4. In June 1995, entire set of directors changed and respondent number 5 and 6 were inducted as new directors of respondent number 3 company, and the petitioner number 1 and respondent number 4 resigned as directors of the company. As per the inter se agreement between the petitioner number 1 and respondent on one side, and the newly inducted directors being respondent number 5 and 6, the entire management was taken over by the new directors with consent of the bank, as is evident from the documents produced by the respondent number one bank itself before the DRT. As far as collateral security was concerned, respondent number 7 stood in and he submitted a collateral security by mortgaging his property by depositing its title deeds. The said property is stated to be valued at around 40 lakhs, which is more than new limits loan granted by the respondent number 1 bank. In these circumstances, petitioner number 2 requested the bank for releasing her from her personal guarantee, and respondent number 4 also requested the respondent number 1 bank to return his bonds, which was given as collateral security. It is pertinent to note here that all these documents have been produced on record by none else but the respondent number 1 bank itself. Both the DRT as well as DRAT have negated the stand of the respondent number 1 bank that on 22nd July 1995, the erstwhile directors of the company, that is petitioner number 1 and respondent number 4, again executed their personal guarantee bonds. The moot question here is, what was the consideration for executing the said personal guarantee bonds after the erstwhile directors have already sold all their shareholdings and have handed over the assets and liability of the respondent number 3 company to new set of directors who in their capacity as director of respondent number 3 company had executed the promissory note, loan agreement and guarantee bonds, as well as they brought in a new surety, respondent number 7, who had submitted the title deed of the property and had secured the interest of the respondent number 1 bank via the new limits loan granted to respondent number 3 company. This is a clear-cut case of novation of the earlier contract of loan. The novation contains two elements, that is discharge of the earlier debts or the debtors and substitution by new debts or the debtors. It is open to the parties to the earlier debt to either enter into new contract of debt or to substitute the debtors by new set of debtors. In the present case, the original loan contract comes to an end when the petitioner number 1 and respondent number 4 walked out of the respondent number 3 company by resigning as its director with the consent of respondent number 1 bank. A new directors walked in who had not only recasted the debt with the express consent of bank, but the respondent number 1 also enhanced the limits on their asking. They also executed a new set of documents, that is promissory note, the loan agreement, and their personal guarantee bonds, and the collateral security by mortgage of the property by respondent number 7. The substitution of new contract is the core of novation, and once a subsequent contract has been executed between the parties, net effect is that earlier obligations stand discharged, and it is the new contract that will define the relationship of the parties, and it is a new cause of action which arises on execution of the new contract between the parties. The intention of the party is very clear from the chain of events as mentioned above. Para 28, my lord. Moreover, there is a material change in the amount being financed by the respondent number 1 on execution of new set of documents in between the bank and respondent number 3 company, acting through respondent number 5 and 6, the new directors. There is no occasion for the bank to plead that although the new directors and surety executed the personal guarantee bonds dated 22nd July 1995 and an immovable property worth more than the value of the limits was given in mortgage, still earlier personal guarantee bonds executed by two erstwhile director and petitioner are still in force. Because as soon as the bank opted to deal with the respondent number 5 and 6 as new directors of the respondent number 3 company in place of petitioner number 1 and respondent number 4, who were the erstwhile directors, and new mortgage has been created on the property of the respondent number 7, and fresh loan documents were executed granting enhanced limits loan on mutually agreed rate of interest, then there is no occasion to fall back upon the earlier guarantees and surety. Respondent number 1 bank has a right to recover its dues from respondent number 3 company as well as from the respondent number 5 and 6, that is the new set of directors, and it has also the right to proceed against the property mortgaged by the respondent number 7, and all of them are jointly and thoroughly liable. Lord, here in that particular case, fraud was not the issue. The issue was somewhat different.
No,
Novation of contract.
Novatio is one thing, fraud is another.
Yes, ma'am. So here this particular issue, there are two issues. Both are intertwined. So that particular issue has to be thrashed out by the civil court. My lord, my submission is that this is under challenge before the Supreme Court, my lord. So it is under, yes, ma'am.
Otherwise also, my lord,
Notice
it is
has
not
been
applicable.
issued, my lord. It is under consideration before the Supreme Court.
My lord, otherwise also, my lord, it is not going to applicable in this case. The DRT decided the matter here. In fact, my lord, the novation limitation, all the aspect, my lord, he can, my lord, urge before the DRT. My lord, the present case which my lord canvassed before this honorable court, wherein DRT decided, DRT, my lord, discharge one of the guarantor or one of the defendant. Therefore, my lord, that appeal, my lord, arises. The present case, my lord, he don't want to, my lord, my respectful submission is this. My lord, he filed an application before the DRT on, my lord, at page number, my lord, 162. Before the... Oh, right. I'm so sorry. I'm so sorry.
Sorry, my lord. I'll just show the effect of this particular judgment with respect of my case. I will just explain, my lord. And my lord, I request my lords to kindly take my petition compilation, my lord. Annexure C, page number 50, my lord.
Annexure C.
Yes, my lord. Page number 50, my lord. That is the original application submitted by the bank before the debt recovery tribunal, my lord.
Lakshmi Vilas.
Yes, my lord. My name, my lords, can find at page number 51, my lord, at serial number 9, my lord. My lord, the first transaction took place in the month of September 2010, my lord. My lords can see the reference at para number 5.4, page number 54, my lord. That is 1.30 lakh as well as 3 lakhs, my lord. Then, my lord, this is the original sanction, my lord.
Correct.
Then, my lord, the second sanction, my lords can see at page number 56, my lord. Para 5.6, my lord. 5.6, my lords can see the sanction of renewal with enhancement at serial number 1, my lord. There is a hanging paragraph. There is a fresh sanction also, sanction of renewal with enhancement. That is dated 14/7/2011.
14/7/2011,
my lord. I am a party to this particular transaction, my lord. First time I am a party to this transaction.
Yes.
I admit, my lord. Then, my lord, the second enhancement, my lords can see at page number 58, my lord. Page number 58, my lord.
7/8/2012.
Yes, my lord. The series of documents have been executed, my lord. The sanction, my lord. Acceptance of sanction. Board resolution, my lord. Undertaking letter, my lord. Letter of concurrence. Letter of revival. Then, my lord, demand promissory note has been executed, my lord. Then letter of continuity.
You are not a party.
I am not a party to this.
So
any of these documents, I am not a party.
But your signature occurs.
Yes, my signature is available. Then, my lord, I request my lords to kindly take page number 59, my lord. There is a subsequent enhancement, my lord. At para 5.11, my lords can see, my lord, the letter of sanction.
11 documents.
Yes, my lord. 11 documents, my lord. I am not a party to this. Then, my lord, there is one more enhancement, my lord. What was originally 1.3 crores, my lord, it was enhanced to 18 crores, my lord. That was in the year 2014, my lord. That started in the year 2013, my lord. At page number 60, at bottom, my lords would find it. I am not a party to this also.
1 to 6 documents.
Yes, my lord. 1 to 6. And for that particular transaction, my lord, the list of documents my lords would find at page number 61. Fresh sanction letter is there, my lord. Fresh acceptance of sanction letter is there. Supplementary agreement, revival letter, my lord. Letter of guarantee is there, my lord. Hypothecation agreement is there. Board resolution is there. I am not a party to this also.
To this also or not?
I am not a party.
Not a signatory.
My signature can be fine, my lord, and it is not my signature, it is a forged signature. And forensic report has been obtained, my lord. On the basis of forensic report, my lord, the police authority have come to a conclusion that my signature has been forged on the unregistered document as well as other documents. My lord, my submission is that, my lord, in a summary proceedings, the DRT can decide novation of contract alone without the
Forgery, fraud.
forgery and all those. Only the forgery has to be decided, my lord, by the civil court. One more question is that, my lord, whether insofar as
No, we are just thinking, suppose if such a contention is allowed,
yes, my lord,
in every
Every
loan
borrower.
transaction, if they raise that,
yes, my lord.
every case has to go to civil court.
My lord, if
That we are not finding some answer to that.
my lord, recently the Supreme Court, my lord, which I was referring to after State of Rajasthan judgment, which is authored by the Justice Oak, my lord, the recent judgment, my lord, what is the responsibility of the advocate while giving the title opinion? What is the responsibility of the bank also has been observed in that judgment.
Title is not in dispute in this case.
No, responsibility of lawyer is one thing.
Yes, my lord.
Suppose if we accept wherever forgery contention is taken, matter has to go to civil court. Then virtually in every case, they will take such contention.
My lord, if I have laid the foundation and I have proved that there is a prima facie case, my lord, then my lord, civil court has to decide. On this honorable court, on one occasion, my lord, it has come to a conclusion that there is a prima facie case, it has to be decided by the civil court. My lord, I personally feel that, my lord, my submission is that, my lord, that is, I have proved it. Prima facie, I have proved it that these documents are tainted documents, forged documents. At least against me, they can wait, my lord. Or within 4 weeks, I will conclude the evidence can be concluded, my lord. Or 6 weeks, my lord. I will get an opportunity to cross-examine the witness of the bank also.
No, I'll just answer, my lord, in respect of, my lord, the application.
Like ಇದೇ ರೀತಿ hearing ಹಾಕೋತ ಹೋದ್ರೆ
ಅಲ್ಲ, ಇದರಲ್ಲಿ, my lord, my respectful submission is this. My lord, DRT is a complete, it is not, my lord, surface action where bank is issuing 13.2, 13.4 and, my lord, sale notice, we sold the property and we appropriate the money.
ಒಂದು ನಿಮಿಷ. ನಮ್ಮ ಪ್ರಪೋಸಲ್ ಸ್ವಲ್ಪ ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಆಗಿ ಉತ್ತರ ಕೊಡಿ. ನಾವು ಏನಾದರೂ ಮಾಡಿ ಇದು ಕೇಸ್ನಲ್ಲಿ ಬಂದ್ಕೊಂಡು ಕೊಟ್ಟಂತ ಅಮೌಂಟ್ ವಾಪಸ್ ಬರಲಿ ಅನ್ನುವಂಥದ್ದು ನಮ್ಮ ಉದ್ದೇಶ. ಅಲ್ಲಿ we will direct, we are only proposal. We do not know. Suppose if we do not agree, then whatever order we want, we have to pass some order. We are just thinking, suppose if we direct the trial court to dispose of that suit itself, but ಬೇರೆ ಯಾರಿದ್ದಾರೆ ಅದ್ರಾಗೆ?
ಬೇರೆ ಎಲ್ಲ ಇದ್ದಾರೆ, all borrowers, guarantors, other, my lord, there are 9 people.
No.
There are, no, kindly see the suit.
The principal borrower, I have to make him as a party because he is the party to that particular transaction I have made. And then the bank.
ಮೂರೇ ಜನ
ಅಷ್ಟೇ.
ಆ ಸೂಟ್ನಾಗ ಯಾರು ಇದ್ದಾರೆ?
Yes, my lord, I will. ಎಲ್ಲರಿಗೂ complete service is complete, my lord. Only it is set down for the cross examination. I will request my lords to kindly take page number 87 of the same compilation, my lord.
87. There are 6 people.
There are 60 yes, sir. Yes, sir.
ನೀವು plaintiff ನೀವು.
Yes, my lord. The different number
6 defendants
yes, different number 1 and 2 are one
same.
Yes, my lord. The different number 3, my lord, is the first borrower, my lord, company.
My lord, 1 and 2 are not same. The reason is this. They, my lord, my lord, they sanctioned the loan. I am the assignee. I have limited role to play in this matter.
Correct. ಹಂಗೆ ನೀವು ಇಬ್ರು ಒಬ್ಬರೇ ಆಗ್ತೀರಿ.
ಅಲ್ಲ, ಒಬ್ಬರೇ ಆಗಲ್ಲ.
Because
all right, ಮೂರನೇದಾರೆ.
My lord, 3 is the principal borrower. 4 is the culprit, my lord. 4 and 5 are the culprit, husband and wife.
4 and 5.
Yes, my lord. The other person is also related to them, my lord. They are cohorts of 4 and 5.
ಅವ್ರದ್ದು ಈಗೆಲ್ಲ WS ಆಗಿ
Yes, my lord. Written statement has been filed.
ನಿಮ್ದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ?
None evidence ಆಗಿದೆ, my lord. They have to cross examine.
ನಿಮ್ಮನ್ನ ಕ್ರಾಸ್
Now,
ಎಕ್ಸಾಮಿನ್
further document I have to mark and they have to cross examine. 13th, my lord. It is set down for 13th.
ಈ 13ಕ್ಕೆ.
Yes.
We will direct them to advance it.
Yes, my lord. I am ready to advance it.
ನಾಳೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
ಅಲ್ಲ, my lord, I may not able to, my lord may pass in order in this. The reason is this. My lord, every borrower before the DRT, which, my lord, every day, my lord, we are assisting the DRT. Every borrower, my lord, guarantor the very same issue, my lord, some or the other, my lord, the only one reason, my lord, the documents are not That also can be decided. Jurisdiction. Section 17 ಅಲ್ಲಿ, it says the tribunal is competent to decide all the applications including cross-suit, cross-claim petitions, since the tribunal are established as a substitute to the civil court to try the suits filed by the bank and all the applications arising out of the same. Thus, the pendency of the claim petition is not hurdled to at all transfer the suit execution petition. So it's
ಯಾವ power to adjudge
Section 17.
17 of
RDBF Act. Provisional ಹೇಳ್ತಾರೆ, it is my lord substitute to the civil court, that act. Lord, apart from that, there must be my lord something wrong in the DRT order. My lord, kindly see the DRT order.
ಅದಾಯ್ತು ಲಾಭ ಮೇಲೆ ಇದ್ದೇವಲ್ಲ ಈಗ even if fraud and fabrication is alleged, even then the tribunal
My
can
lord,
decide
my
that
lord,
issue.
DRT may discharge the present guarantor. That's what happening in every cases. In fact, the present case which is relied, my lord, in the very DRT have a right to, my lord, under section 19(5). DRT have a right to, my lord, discharge the borrower if he is able to make out a case before the DRT. That's what, my lord, Honorable FX Court said in the case of, my lord, Bank of Rajasthan.
The substitutes civil court. They have a civil court power for deciding the provisions.
Non-copy
Substitutes.
Non-copy would consult.
My suit in before the DRT, my lord, 2015. The suit filed before the civil court, my lord, 2019.
of documents.
In addition to that, my lord, one judgment, my lord, I would like to rely that is, my lord,
Support of that, he banks upon this decision. Nodi. 1999.
one more judgment is the context of, my lord, arbitration, where, my lord, the issue came before the Honorable Apex Court saying that whether tribunal can decide the fraud. My lord, I'll just, very good. My lord, I would like to rely, my lord, in the SLP 13132 of 2020, para 816, internal page, my lord, 49. 8.616. The ground on which fraud,
page
49, 8.16. The ground on which fraud was held on non-arbitrable earlier was that it would have entailed voluminous of extensive evidence and would be too complicated to be decided in arbitration. In contemporary, the arbitration tribunals are required to be traversed though volumes of materials in various kinds of disputes such as oil, natural gas, construction industry, etc. The ground that allegations of fraud are not arbitrable is wholly archaic view, which has become obsolete and deserves to be discarded. However, the criminal aspect of a fraud, forgery, fabrication, which would be visited with the penal consequences and criminal sanctions, can be adjudicated only by a court of law, since it may be result of conviction which is in the realm of public law. In the present case, the allegation of fraud in respect of the invocation of the bank guarantee are arbitrable, since it arises out of the dispute between the parties inter se and not in the realm of public law. My lord, here
he also presses into service. This reported global mercantile. The report internal global mercantile versus Indo-Unique Flame. There are 8.16 and 17 in support of the said contention.
My lord, one more authority, my lord, which I filed along with the compilation of judgment on 1st July 2024. The very same issue, my lord, the 1 July 2024. The judgment starts from, my lord, page number 38. More compilation. In the case of, my lord, Bank of Rajasthan Limited versus VCK Shares and Stock Broking. Page number 38.
Page?
More into son. Para number 44 in the Shurvagate starts from, my lord, 44. Page number 64, my lord, is relevant. Para number 44. In a similar, my lord, circumstances. Now, if we turn to the objective of RDB Act, read with scheme and provisions thereof, it is abundantly clear that a summary remedy is provided in respect of claim of the bank and financial institution, so that recovery of the same may be not be impeded by the elaborate procedure of court. The defendant has the right to defend the claim, file a counterclaim in view of section 6 and 8 of the section 19 of RDB Act. In the case of pending proceedings to be transferred to DRT section 31 RDB Act, look care of the issues of mere transfer of the bank's claim, albeit without transfer of the counterclaim. Thus, of the debtor desires to be instituted a counterclaim that can be filed before the DRT and will be tried along with the case. However, it is subject to caveat that bank may move for the segregation of that counterclaim to be relegated to proceeding before the civil court under section 1911 of the RDB Act, though such determination is to take place along with the determination of the claim of the recovery of debt. 45. We are of the view that there is no provision in the RDB Act by which the remedy of a civil suit by the defendant in claim by the bank is ousted, but it is the matter of choice of the defendant that defendant may file a counterclaim or may be desirous to availing the most strenuous procedure established under the code, and that is a choice which is takes with the consequence thereof. we may notice that RDB Act was amended from time to time, including by amendment this para, my lord. Then I'll come to, my lord, para 53, 54, 55, page number 66. We certainly would not like to the process in which under RDB Act impeded to any manner filing and separate suit by the defendant chooses to do so. A claim petition before the DRT has to be proceeded in particular manner and would so proceed. There can be no question of stay of those proceedings by a civil proceeding instituted by the defendant before the civil court. Thus, a suit would take its own course, while petition before DRT would take its own course. We appreciate that this may be in the nature of parallel proceedings, but then it is a defendant's own option. We see no problem with the same, and no long as the objective of the having expeditious disposal of the claim before the DRT under the RDB Act is not impeded by filing a civil suit. Thus, it is not open to a defendant who may have taken recourse to civil court to seek a stay on the decision of DRT awaiting the verdict on the suit before civil court, as it is a matter of choice. We thus make it abundantly clear that in case of such option exercised by the defendant who filed the independent suit, whatever be the nature as relief, the claim petition under RDB Act would continue to proceed expeditiously in terms of the procedure established thereon to come to a conclusion whether a debt is due to the bank and financial institution and whether the recovery certificate ought to be issued in that behalf. We may say that if the legislature were think otherwise, nothing prevented legislature not to prevent it now from making suitable amendments in the RDB Act to meet such scenario. In view of the discussion, aforesaid the question framed above, in this jurisdiction of civil court to try suit filed by the borrower against a bank or financial institution ousted by virtue of the scheme of the RDB Act in relation to the proceedings for recovery of debt and bank's financial institution. And paramalad next pair also. In the absence of such power existing, the civil court and independent suit filed by the borrower against a bank or financial institution cannot be transferred to tried along with the application of the RDB Act. Is it the matter of option of the defendant that claim under RDB Act? However, the proceedings under RDB Act will not have impeded in any manner by filing a separate suit before the civil court. My lord, in fact, my lord, one more compilation judgment which I filed, wherein once they filed a written statement before the DRT. Yes. My lord, the compilation which I filed it on, my lord, 23 November 2024.
He also presses into service expedition in Bank of Rajasthan versus versus VCK shares and stockbroking 2023 1 ACC 1 paragraph 53, 54, 56. Forty-four also.
Yaudu?
44. 46. Yes.
My lord, now, my lord, that there must be something wrong in the DRT order. My lord, kindly come to, my lord, the application which they filed by, my lord, the petitioner at page number 162. On dated, my lord, 25/3/2022. In the petition filed by, my lord, the for the reasons stated in the accompanying affidavit, the defendant number 9 above named prays that honorable court may please to stay the further proceedings in the above matter. So sorry.
Page
162, annexure J, in the petition, my lord. 162. In the writ petition.
This is application.
Howdu. my lord, pursuant to, my lord, this application, the DRT has been passed in order and DRT confirmed the same order. For the reasons stated in the accompanying affidavit, the defendant number 9 above named prays that this honorable court may be pleased to stay the further proceedings.
Day of proceedings, need not work. Read it. Next.
DRT pass an order, detail order. My lord may come to page number 170 onwards. My lord, DRT pursuant to that application, DRT pass an order. I'll just skip, my lord, pair number 1 to, my lord, 7, 8 onwards, my lord, little relevant. As stated above, page number 173, my lord. As stated above, the defendant number 1 to 3 remained ex parte. In OA proceedings, defendant number 4 to 8 filed a written statement on 11/4/2016, admitting availing the loans by defendant number 1 to 3. It is also admitted by them that they have stood as a guarantor for the term loan of rupees 130 lakh availed by the defendant number 1 to 3 from the respondent applicant, for which they have also offered a collateral security of a scheduled MO property. However, it is submitted therein that the enhanced credit facilities were granted without their knowledge. Going by the written statement filed OS number so and so, filed by the 9 defendant, is also admitted availing the credit facilities by defendant number 1 to 3. It is admitted by him, he executed letter of guarantee dated so and so, guaranteeing due repayment of amounts of rupees OCC limit of 750 lakhs. It is also admitted by him that the created equitable mortgage over the G scheduled property, immovable property by depositing title deeds on 25/7/2011 in favor of the respondent applicant. The execution of revival letter on 9/8/2012. Also, it is admitted by the petitioner, 9 defendant. However, guarantee of enhancement of the credit facility is denied by the petitioner, 9th defendant, AW1. The authorized officer of the respondent applicant filed a proof affidavit support of his averment in the OA and got marked exhibit A1 to A145 to corroborate the pleadings as against the loan referred to in OA. Now the burden of proof has shifted on the upon the defendant. Though the petitioner, 9 defendant, has contended against a decree as against him and G schedule immovable property, he also not filed a counter.
ಯಾವ ಸ್ಟೇಜ್ ನಿಂದ OA ಏನಾಯ್ತು?
My lord, we conclude, my lord, we have filed our, we adduce our evidence and we argued our matter. The matter is posted for orders. That time, my lord, they filed a present writ petition and this writ petition showed a limited indulgence at the application.
OA ಆಯ್ತಾ? OAದಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಸ್ಟೇ ಮಾಡ್ರಿ ಅಂತ.
Haki, my lord, DRT said, in fact, you are
slowly you will go. That OA, in that OA, you filed application for stay of proceedings.
Yes.
Correct?
Yes.
That application came to be rejected.
Yes, ma'am.
Then you filed appeal on that.
Yes, ma'am. Thereafter, I have come.
DRT Chennai.
Oh, thereafter, I have come before this honorable.
That was rejected.
Yes.
Therefore, you are here.
In the interregnum, my lord, I filed an application saying that I may be permitted to cross-examine. That application also opposed by the learned counsel.
Cross-examine whom?
The bank witness. That also came to be rejected.
In DRT.
DRT, my lord, DRT.
ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರಿ ಇದ್ರಾಗ.
My lord, that is subsequent, my lord, I have filed a separate, I have initiated.
Writ petition is
Yes,
pending.
Yes, ma'am.
page number 27, DRT order as held before this honorable. I'll just read the DRT order for a moment. My lord, there must be something wrong because DRT said, if you have section 10 of CPC, section 10, my lord, I'll just read the DRT order for a moment. My lord, page number, it starts from page number 27, 28 orders per there. This appeal against order dated 26/2023, DRT Bangalore dated so and so. Respondent, brief facts of the appeal are as follows. The respondent, original Lakshmi Vilas Bank, filed the original application 173 of 2015 for recovery of rupees 12,97,04,007 together with the interest. Appellant is the defendant number 9 in filed written statement disputing the claim, mainly contending that the claim is based forged created document. Appellants herein OS filed an OS number.
So sorry. Para 11 even.
Para 11.
Page 175.
Para 11.
ಅದೇ ನಿಮ್ಮ ಆರ್ಡರ್.
ಅಲ್ಲ, para 11 ಇಲ್ಲ, DRT order. Para 10 is last.
ಅಲ್ಲ, DRT order.
DRT order.
Para 11 ಗೆ ಬನ್ನಿ.
DRT.
Page number
175, my lord, para 11.
10, 11. 11 ನೋಡಿ.
It is specifically contention of the petition 9 defend the adjudication in the OA during the pendency of so and so, and Session Judge Bangalore is impermissible, and hence there is a need to stay of the proceedings OA till the disposal of the suit of civil court. The jurisdiction, powers and authority of debt recovery tribunal is defined under section 17 of the act, which states that the tribunal shall exercise on and from the appointed day the jurisdiction, powers and authority to entertain the decide the application from the banks and financial institution of recovery of debt due to such banks and financial institution. A debt recovery tribunal is established under section 3(1) of the act for expeditious adjudication of the recovery of debts due to banks and financial institution and for merits connected therewith or incidental thereto. The word debt is defined section 2G of the act and includes the fraudulent debt is also. It was held in the Honorable Supreme Court in the case of State Bank of India versus Madhumita Construction Private Limited. That debt defined section 2G of the Act includes fraudulent debts, and the fraudulent nature of the debt does not take away the jurisdiction of the tribunal under this.
ನೀವು ಸೂಟ್ ಹಾಕಿದ್ರಲ್ಲ,
Yes, ma'am.
ಸೂಟ್ ನಲ್ಲಿ on what ground the matter came to High Court?
They filed an application under section order 7 rule 11, seeking of the rejection of the plaint, my lord.
That is rejected.
That application was allowed.
Okay.
And being aggrieved by that particular order, I preferred an appeal before this honorable court. And this honorable court, hearing both the side, including this particular issue, whether the jurisdiction is ousted or not, then this court came to a conclusion that civil court jurisdiction is not ousted. And I have made out a prima facie case of a fraud.
So what it did by way of interim order?
The interim order, my lord. The interim order is that, my lord, they are, there is no, not to alienate anta ide ashte. That will not, that will not protect.
All right. So, the point which you canvass is,
Yes, ma'am.
there is novatio in the first part.
Yes, ma'am.
In the second part, there is fraud.
Yes, ma'am.
Fraud is being adjudicated before the civil court.
Yes, ma'am.
The application under 711 having been allowed, order is put in challenge and matter is admitted
Yes, ma'am.
by a single judge of this.
No, it disposed of, my lord.
That is disposed of, saying
Disposed of.
that the matter is remitted back
Yes,
to.
my lord. A detailed
that-
order, my lord. It is a, if my lord takes annexure H, page number 121.
Holding that.
The detailed order has been passed saying that
ಏನಂತ hold ಮಾಡಿ just ಹೇಳಿ.
the jurisdiction of the civil court is not ousted and civil court has to decide this particular issue.
What is that issue?
The declaration that these documents are product of fraud. Only civil court can grant this relief antanu ಹೇಳಿದ್ದಾರೆ.
Order ಎಲ್ಲಿದೆ?
Annexure H, page number 121, my lord.
One 121, na?
Yes, my lord.
Ali, tribunal has no power,
Yes,
only
yes.
civil court has got power.
Yes, my lord. All those things, aspects, those submissions have been considered.
ಹೊಸಮನಿ ಅವ್ರದಾ?
Yes, ma'am. Yes, ma'am.
Page 120.
Page number 131, my lord. My submission was that, my lord, on 2 count, my lord. That is, they made submission that in view of section 34, the jurisdiction is ousted. Then, my lord, second point what I submitted before this honorable court. Debt recovery tribunal cannot be equated with civil court and no declaratory relief can be granted by the debt recovery tribunal. Then, my lord, at page number 133, Madia Chemical, more particularly para 53 has been extracted, my lord.
You are a party there.
I am
Yes,
a
ma'am.
party. That judgment, my lord, is not applicable. That reason is this. Para 11, page number 129, in this very same judgment, they are assailed, my lord, my section 14 order. My lord, 11, I'll just read, my lord, defend number 2. The assignee filed a separate return statement contending that suit was not maintained in law and was barred under section 34 of the Surface Act, not under RDB Act. I would have filed under section 20. If the DRT, my lord, they would have challenged it. Surface Act, it was stated that in relation to the very same transaction, defend number 1 filed OA number 173 of 2015 before DRT Bangalore against plaintiff, and defend number 3 to 6 was pending. It was further stated that it has filed a criminal miscellaneous number so and so under section 14 of Surface Act, which is allowed on, my lord, on 23/10/2018. The physical possession was taken through process of court on 18/12/2018, and the secured asset was liable to be sold through auction of recovery of secured debt. Through the plaintiff was aware of the proceedings, instead of approaching the DRT, filed the instant suit, which is not maintainable and filed only with the view of scuttle the distract and protect the legal proceedings. Then, my lord, I'll come to, my lord, page number 143, para 20, in the internal page 23 in the judgment, my lord.
Read
143.
Para 14 question.
Para 14. Plaintiff filed an objection to IA number 4. It was contended that the plaintiff was seeking for a relief of declaration discharge from the guarantee and surety.
Paragraph 14.
14. Based on the pleading, trial court framed following issues.
ಈ issue ಹೆಂಗ್ ಆನ್ಸರ್ ಮಾಡ್ಯಾರ?
Whether the suit is
Maintainability of the suit.
ಹೌದು, my lord, section 34, I'll just read of Surface Act. Whether the suit of the plaintiff is maintainable in view of section 34 of the Surface Act.
Correct.
my lord, kindly come to my lord.
Your proceedings are not
Now
surface
before
Act.
this honorable court, my lord, DRT proceedings. That time, my lord, when the suit pending before the civil court was surface
Surface.
action, section 14 order assailed. That is the reason, my lord, I filed an application under order 7 rule 11 read with section 34.
Slowly. This judgment did not consider the effect of DRT Act.
Law.
Consider ಮಾಡಿಲ್ಲ.
My lord, my
ಈಗ ಅಪೀಲ್ ಇರೋದು DRT ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸೇರ್ದು DR 93 ಆಕ್ಟ್ ಕೆಳಗಡೆ.
yes, my lord, 1993 Act. Yes.
ಅದ್ರ ಮೇಲೆ ನೀವು ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ, ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು, ಯು ಗೋ ಟು DR 80, ದಟ್ ವಾಸ್ ಅಂಡರ್ 93 ಆಕ್ಟ್ ಓನ್ಲಿ.
Yes.
ಕರೆಕ್ಟಾ?
Yes, ma'am.
ಇಲ್ಲಿ
Yes, ma'am.
93 ಆಕ್ಟ್ ಕೆಳಗಡೆ ಇರೋ ಟ್ರೈಬ್ನಲ್
Yes, ma'am.
ಇಟ್ ಡಸ್ ನಾಟ್ ಹ್ಯಾವ್ ಪವರ್ ಟು ಅಡ್ಜುಡಿಕೇಟ್ ಫ್ರಾಡ್ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಅಂತ ಅನ್ಕೊಂಡು ಯಾವ ರೂಲ್?
Yes, madam.
What he says is,
Yes, my lord.
it has nothing to do with this judgment, has nothing to do with anta.
Except,
My lord, after my learned friend referred to state of Rajasthan, my lord. And after the referring to the Bank of Rajasthan, my lord, there is one more judgment which has been rendered, my lord. We'll just refer to that.
ಯಾವ ಆಕ್ಟ್,
Yes.
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್
Yes, ma'am.
93 ಆಕ್ಟ್ ಕೆಳಗಡೆ
Yes.
ಫ್ರಾಡ್ ಫ್ಯಾಬ್ರಿಕೇಶನ್ ಡೂಪ್ಲಿಸಿಟಿ
Yes.
ನ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಹೋಲ್ಡ್ ಮಾಡ್ತು? ನಮ್ಮ ಪ್ರಶ್ನೆ ಅದು. ಇದು
Yes.
ಎಲ್ಲ ಸರ್ಫೇಸಿ ಇದು.
Yes,
ಸರ್ಫೇಸಿ ಬಿಟ್ಟಾಕಿ ವಾಟ್ ಹಿ ಸೇಸ್
correct, my lord.
we have nothing to do with surface.
In this judgment, my lord, both SURFACE as well as the RDB Act has been considered, my lord, regarding ousting the jurisdiction of the civil court, my lord. First, I request my lords to kindly take para 41, my lord. Yeah, okay. Para 41, my lord. The head, my lord, the heading is like this, my lord. Maintainability of the civil suit against the bank under the RDB Act, my lord, 1993. I will only read 2 lines, my lord, then I will request my lords to consider earlier paragraph. In Bank of Rajasthan versus VCK Shares and Stockbroking Services Limited, due to conflicting decision of the benches comprising of 2 judges, a reference bench of this court was called upon to decide whether the jurisdiction of the civil court is ousted.
Not ousted ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು.
Yes, yes, ma'am.
Go to next.
Yes, ma'am. Now I request my lords to kindly take para 38, my lord. Para 38, my lords. Hope my lord says para 38.
Para
38, my lord. Digital page number 30.
ಅಲ್ಲಿ suit is not barred.
Yes.
Suit for what?
Suit for declaration with respect of her share in the joint family property, my lord. In this case, before the Supreme Court. Yes.
Correct. Partition ಅನ್ನ ಹೆಂಗೆ DRT
Yes,
decide
ma'am.
ಮಾಡ್ತದೆ?
Yes, my lord. I am drawing a similar parallels from that, my lord. Here, my lord, I am protected. In addition to this, I am protected under Madia Chemicals and Nahar Industry. Para 38, my lord. The heading is like this, my lord. Para 38, my lord. The
Tribunal is a creature of
tribunal is a
statute.
creature of statute and cannot go beyond the 4 corners of the SURFACE Act. Yes, my lord. Then they have referred to. The Debt Recovery Tribunal is a creature of RDB Act 1993 and is empowered to exercise powers under that Act and SURFACE Act 2002. The tribunal is bound by the powers conferred to it by the parliament. Interestingly, when this court in Harsh Govardhan.
Tenant cannot approach.
Yes, my lord.
Next.
Yes, my lord. Then para number 30. Yes, my lord. In this particular Saudagar case, my lord, held that tenant cannot approach the DRT because of the repossession, and then there is an amendment, my lord. I will not read it. Para 30. This court in MP Waqf Board versus
Cannot transgress the powers of the
Yes, my lord.
powers given by
Yes,
the
my
Act.
lord. So this particular judgment has been followed too. The tribunal, power of the tribunal. Then, my lord, the Constitution bench in Om Prakash Gupta versus Ratan Singh has declared that tribunals, being creature of the statute, have limited jurisdiction. The relevant paragraph, my lord, 4, and they have extracted it, my lord. Then, my lord, at para number 41, my lord, the Bank of Rajasthan has been discussed, my lord. Para 43 is very important, my lord. My lord, this court in Dwarka Prasad Agarwal versus Ramesh Chandra Agarwal has explained that, sorry, my lord, para 43.
Correct.
This court in Dwarka Prasad Agarwal versus Ramesh Chandra Agarwal has explained that bar of jurisdiction of civil court is not to be readily inferred. Such provision requires strict interpretation. It was further held that this court would lean in favor of construction which would uphold the retention of the civil court's jurisdiction. Then they have extracted the relevant paragraph, my lord. Thereafter, the court said that civil suit has to continue.
That was a matter relating to partition.
Partition, my lord. Declaration and partition, my lord.
Correct.
Because mortgage which was executed in favor of the bank, she sought for the declaration that it is not binding and it is not binding on her share.
She was not a borrower.
Party. Yes,
neither
she was not a party to that.
Correct.
Yes, ma'am. Here, my lord, I am also not a party to the subsequent transaction which has took place between the bank as well as this particular.
To contend that before the tribunal.
My lord, my submission is that, my lord, the tribunal cannot decide this particular issue.
Which issue?
This particular issue of fraud.
Fraud.
Yes, ma'am.
Where is the judgment to that effect?
My lord, I sought for the permission. My lord, I sought for the permission. That application was opposed by them, and I am before this honorable. And they say that I have to prove it. How I have to prove it? In a full-fledged trial only I can prove it, my lord. I have to adduce the evidence. I have to examine the others. I have to produce contemporaneous document also. And then, my lord, they have to examine their witnesses. Then only it is possible.
One more thing we are asking you.
Yes, ma'am.
Now, suppose if the tribunal DRT has to hold trial now.
Yes, my lord.
At that stage, you had moved the application.
Yes, my lord.
Let the DRT proceedings go on.
Yes, my lord.
Your proceedings go on there.
Yes, my lord. But if it is decided, my lord, then my entire exercise become futile, my lord.
No, we'll tell now DRT has to hold proceedings.
Yes, my lord.
Is it not?
Yes, ma'am.
And in the meanwhile, let suit be decided.
Yes, ma'am.
Why DRT proceedings should be halted?
My lord, last occasion, my lord, I referred to one particular judgment of the Delhi High Court, my lord, authored by Justice Ravindra Bhatt, my lord. In similar circumstances, my lord.
Considering Mardia and other.
Yes, ma'am. There is a direction to the suit to dispose of the suit within a timeline, my lord.
Correct. Even if suit is disposed of.
Yes, ma'am.
Why this proceeding should be halted? Whatever civil suit will say.
Yes, ma'am.
That you can produce before the tribunal at the appropriate stage.
Lord,
let the proceedings in the DRT go on.
Yes, ma'am.
And the decree shall not be drawn up till after the
disposal. Yes, ma'am.
Disposal of this one. What do you say about this?
My lord, one submission, my lord.
It will take its own time.
DRT, my lord.
I will make one more submission, my lord.
Okay, submission.
There are totally 9 properties involved, my lord. With respect of my properties, my lord, it can be kept in abeyance. I will complete the proceedings, my lord.
It's only one property, my lord. I have a security, my lord. I'll just point out. If they have any apprehension that, my lord, the documents which they produce before, because all the original documents before the DRT, my lord may direct to refer the matter to forensic. Because the civil court is exactly the same thing going to happen, my lord, because loan sanction in the 2011. Now, my lord, the manager is
clarity illa, submission dalli, articulation illa.
My lord, the original documents which we already adduced the evidence before the DRT, the documents before the DRT. Let them file a necessary application. For, my lord, that their only contention before this on court, that
application for full sentence madi.
To refer the, my lord, the signature part to, my lord, forensic agency to, my lord, whether the signature is genuine or not.
His case is tribunal cannot decide whether there is fraud or not. Another case.
My lord, the moment, my lord, forensic, my lord may direct the DRT to refer the, my lord, that all the documents which they are disputing in respect of their signature to forensic report. My lord, after, my lord, the report comes. My lord, DRT have all the powers to, my lord, they can, my lord, release from their security, or, my lord, they can from the, my lord, as a defendant, or, my lord, as a guarantor. They discharge the guarantee. My lord, therefore, my respectful submission, my lord may direct whether they want to do a cross-examination in a time-bound manner. My lord may direct the DRT to, my lord, accept their my lord application, and, my lord, do the cross-examination in time-bound manner, or, my lord, they dispute in respect of the my lord, documents in signature part of the documents. It may be referred the matter to, my lord, forensic agency, and in a time-bound manner.
One nimisham. Idu one aspect. Second pattern is DRT proceedings suit eradu nadili. So far as there are 11 properties, yes, 11 properties. Decree no agli, 10 property ಸಂಬಂಧಪಡಂಗೆ execution agli, ಇದು ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಲ್ಲ, that will be subject to the result of a decree ಇದ್ಬಿಡ್ಲಿ ಅದ್ರದ್ದು DRT patterns. We are just thinking, we are not,
Yes, no, I
we are
understand.
not
No,
passing on. We are just thinking. The suit with regard to duplication, fraud, fabrication,
Yes,
suit will proceed because you are a party to the proceedings, although your contention is it related to Surface Act.
Please, my lord.
We'll come to that one. The DRT proceedings also shall go on
yes, ma'am.
in a full-fledged
Yes,
way, as if there is no suit.
Yes, ma'am.
Let DRT pass the decree also,
Yes, ma'am.
but execution of decree shall be confined to 10 properties.
Yes, ma'am.
So far as a decree in relation to 11 property which you are given is concerned,
Yes, ma'am.
that will be subject to the outcome of the suit.
My lord, my difficulty is this for this.
ಅವಾಗ ಎಲ್ಲದೂ
ಅಲ್ಲ,
proceed ಆಗ್ತದೆ.
my
ಇಲ್ಲ ಅದು ನಿಂತ್ಕೊಂಡ್ಬಿಡ್ತು.
My difficulty is the 10 property, my lord, it is, we are not able to recover the money, my lord, that we have our own difficulties to recover the money from that, my lord, now I have to recover 81 crore. The one property which is, lord, it is not in dispute, my lord, he extended his guarantee and he even provided as a mortgage to this tune of, my lord, 7.5 crore in the year of 2011. It is not in dispute. He has availed a loan, my lord, we is seeing this property. My
ಆಯ್ತು
lord.
ಈಗ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು. ಬೇರೆ ಏನಾದ್ರು ಹೊಸದಿದೆಯಾ?
ಇಲ್ಲ, one judgment, my lord, I'll just tell you, my lord, that section, my lord, before that, my lord, section 10 of CPC.
10 of CPC ಹೇಳಿ ಓದಿ. Stay of suit.
Stay of suit, my lord, in respect of my suit pending for DRT in the year of 2015. The present petition, my lord,
ಅದ್ರ ಕೆಳಗೆ ಹಾಕ್ಯಾರ ಅವ್ರು.
2019. Therefore, my lord, that earlier suit,
10 of 10 is not applicable.
151 is very much available.
150 ಓದಿ. 10 speaks of 2 suits.
ಹೌದು.
ಎರಡು ಸೂಟ್ ಆಗಲ್ಲ.
Yes.
that one judgment, my lord, which I.
Because under CPC,
Yes.
suit is not defined. Section 25 says a suit is instituted by the presentation of the plaint.
Yes.
So the one which you have filed in the DRT is not a suit. So section in terms may not be applicable, but instead of 151 will be applicable.
And more
151 applies to whom?
applies.
151 does not apply to tribunal.
My lord, I read section 22(2)(h) read with 151 I have mentioned in my application.
Then
Section 22(2)(h) of RDB Act read with section 151 I have mentioned. My lord.
151 is not applicable because 151 is not part of the CPC. Inherent power of the court are not part of the CPC. They are only recognized by 151. That's all. That's how courts have said. In fact,
Yes.
so inherent powers are alien to tribunals unless law recognizes such power, grants such power. Under 482 of CRPC, 25 of Karnataka Land Revenue Act, then 151 of CPC, like this it is. Okay, yes. Now where is the power with which it can stay the proceedings? Which is that section?
There is no specific provision in the RDB Act, my lord. There are no specific provision in the RDB.
Then how can you invoke?
Lord, I have general power of the RDB, the tribunal under section 22(2)(h) I have.
22(2)(h).
Yes, ma'am.
Any other matter which may be prescribed.
Yes.
And
To do the justice between the party.
Summoning, production of document,
Yes,
receiving evidence,
yes, ma'am.
issuing commissions,
Yes, ma'am.
reviewing of its decisions.
Dismissing application, setting aside order of dismissal of any application. for-
ಇದ್ರಾಗ ಯಾವ್ದ್ರಲ್ಲೂ ಬರಲ್ಲ.
Yet any other matter
other
which may
matter
be
which may be
prescribed.
That may be prescribed ಅದು. Prescription ಎಲ್ಲಿದೆ? Prescription ಇದ್ರಷ್ಟೇ ಬರ್ತದೆ, ಇಲ್ಲಿರಲಿಲ್ಲ. Prescribed by rules ಅಂತ ಓದಿದಿರಲ್ಲ.
Yes.
Where is the prescription? ರೂಲ್ಸ್ ಇದಾವ ಇದಕ್ಕೆ?
Yes, rules are there.
That will put-
Yes.
ಎಲ್ಲಿದಾವ ರೂಲ್ಸ್?
1925.
93.
My lord, there is a separate chapter, chapter 4, my lord, that deals with the procedure of tribunal and under which we filed the application.
ಚಾಪ್ಟರ್ 4
And this was one of the
ರೂಲ್ಸ್ ಕೆಳಗ
act, section 19, my lord.
19.
Section 19, my lord, subsection 25. Subsection 25, my lord, the tribunal may make such orders and give such direction as may be necessary or expedient to give effect to its order or
ಅದು
to
apply
prevent abuse of its process or secure the ends of justice. And more or less the similar to that of the 151, my lord.
ಲ್ಯಾಂಗ್ವೇಜ್.
Yes, my lord.
All right.
My lord, one more submission. Only when they filed the
ಬಟ್ ಡಿಸ್ಚಾರ್ಜ್ ಇದೆಯೋ ನೊವೇಶಿಯೋ ಇದೆಯೋ ಅದು ಟ್ರೈಬ್ನಲ್ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ವಿ ಆರ್ ವಿತ್ ಯು.
that question is required to be decided by the civil court. The fraud.
ವೈ ನೊವೇಷನ್ ಇದೆಯೋ ಇಲ್ಲ ಅಂತ ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ಶ್ಯೂರಿಟಿ ಇಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ವಿದಿನ್ ದಿ ಡೊಮೇನ್ ಆಫ್ ದಿ ಟ್ರೈಬ್ನಲ್ ಓನ್ಲಿ.
Even limitation is.
Lord, my submission is that, my lord, the issue of novation as well as the fraud on me is interconnected and intertwined. And one issue cannot be bifurcated from the fraud, more particularly as against me is concerned. And for that reason only, it is my case that it is civil court which has to decide it. Because it cannot be segregated. These two issues cannot be segregated. A person who is not alleging the fraud, and if he says that there is a novation of contract, that particular issue can be decided by the DRT. But if a person says that by virtue of a fraud and also subsequent agreement, which I am not a party, both are the intertwined issue which has to be decided by the civil court only. Because only one issue the DRT cannot decide, my lord. If it decides one issue, it amounts to prejudging the suit. And one more thing is that, my lord, if those letters I have not issued, letter of guarantee, letter of revival letters I have not issued, the entire claim as against me becomes a time-barred debt. They cannot proceed against me at all.
That can be decided by the.
Yes, my lord, that can be decided by the DRT.
Now what we are thinking is.
Yes, my lord.
ನೊವೇಶಿಯೋ ಆಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಎರಡನ್ನೂ ಲಿಮಿಟೇಷನ್ ಟ್ರೈಬ್ನಲ್ ಡಿಸೈಡ್ ಮಾಡಿ. ಬಟ್ ಇಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಸ್ಡ್ ಅಪಾನ್ ವಿಚ್ ಟ್ರೈಬ್ನಲ್ ಈಸ್ ಡಿಸೈಡಿಂಗ್ ನೊವೇಶಿಯೋ ಆರ್ ಫ್ರಾಡುಲೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, that should be decided by the civil court. Tribunal proceedings ನಡೆದು ಬಿಡ್ಲಿ ಎಲ್ಲ.
My respectful submission, my lord, even that aspect also can be looked into by DRT.
How ಹೆಂಗೆ?
My lord, DRT have a, my lord, under 22(2)(h).
ಅದು ಹೇಳಾಯ್ತಲ್ಲ, ಬೇರೆ ಏನಾರ ಹೊಸದು.
They can refer the matter to forensic. Let them file an application, my lord, we will.
ಫೊರೆನ್ಸಿಕ್ ರೆಫರ್ ಮಾಡೋದು ಬೇರೆ, ಪವರ್ ಟು ಡಿಸೈಡ್ ಬೇರೆ, ಪವರ್ ಟು ರಿಸೀವ್ ಎವಿಡೆನ್ಸ್ ಟು ಡಿಸೈಡ್ ಬೇರೆ. ಪವರ್ ಟು ಡಿಸೈಡ್ ಇರಬೇಕು. ಅವಾಗ ದೇ ಮೇ ಹ್ಯಾವ್ ಇನ್ಸಿಡೆಂಟಲ್ ಪವರ್ಸ್ ಟು ರಿಕ್ವೈರ್ ಎಕ್ಸ್ಪರ್ಟ್ ಒಪಿನಿಯನ್, ದಿಸ್ ದಟ್ ಎಟ್ಸೆಟ್ರಾ. ಅವಾಗ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಇಲ್ಲೇರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
But based on
ನಾವು ಮಾಡೋದ್ರಿಂದ ನೀವ್ ಹೆಂಗ್ ಅಗ್ರಿ ಆಗ್ತೀರಿ ಅಂತ ಗೊತ್ತಾಗ್ತಾ
the
ಇಲ್ಲ.
most, my lord, before the civil court also, my lord, two issue can be raised. One is, my lord, they can do a cross examination of my officer. Second one is, my lord, they can refer the matter to, my lord, forensic agent whether the signature is forged or not.
ಎದಕ್ಕೆ?
By the civil court.
ಸಿವಿಲ್ ಕೋರ್ಟ್.
Adhine, my lord may direct the civil court to do it. Sorry, DRT to do it. DRT can do it under 22H.
ಪವರ್ ಬೇಕಲ್ಲ, ನಾವು ಕೋರ್ಟ್ ನಿಂದ ಪವರ್ ಕೊಡಕ್ ಬರ್ತದ.
22 to actually. In fact, my lord.
Heard.
Grateful. My lord, one authority, only last one authority, where once they file a written statement before the DRT, they can't judge before some other court. That is one Delhi High Court said, my lord, that compilation of judgment which I filed on 23rd November.
Fraud.
Fraud alla. Once they filed an objection before the before the DRT, no, my lord, later they can't file a civil suit.
It is other way, my lord. Earlier my suit has been instituted, then I have filed.
ಆಮೇಲೆ ನೀವು ಇದ್ರದ್ದು ಬಂದಿದೆ. It was instituted earlier only.
Yes, ma'am. Then I refer to this suit also in the written statement.
Written statement filed it on, my lord. The dates.
Brother,
No. Please.
before that he had filed a suit.
Yes, my lord.
ಅವಾಗ ಅಪ್ಲೈ ಆಗಲ್ಲ ಈ ರೂಲಿಂಗ್. Otherwise it may arguably it may be, we do not know. ಕುತ್ಕೊಳ್ಳಿ. Dictation ನಿಮ್ಮದ question.
The compilation judgment which I filed, the compilation judgment which I filed on 23rd November 2024, there are 4 judgments we relied.
ಇಂದು 50 ನೀವು ಮಾಡ್ರಿ, ಯಾವ್ದು ರಿಲೆವೆಂಟ್ ಇರ್ತದೆ ಮಾಡ್ತೇವೆ, ಉಳಿದಿದ್ದು ಬೀಸುಗಿ. ನೀವು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದು ಒಟ್ಟೊಂದು ನೋಡ್ಬೇಕು ಇಲ್ಲ. Supreme Court said only relevant of the judgment should be referred to. ನೀವು ಎಲ್ಲ ತಂದ್ಕೊಂಡು 1000 ಜಜ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಅದ್ ಮಾಡ್ಕೋತ ಕೂತ್ರೆ ಮುಂದಿನವ್ರು ಗೊತ್ತಿಯೇನು. ಗ್ರೇಟ್. ಅದೆಲ್ಲ ಹೇಳಕ್ ಬರಲ್ಲ. ನೀವು ಜಜ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ ಇಡಿ ಇರ್ರಲೆವೆಂಟ್ ಎಲ್ಲ ಹಾಕಿದ್ರೆ ನಾವೇನ್ ಮಾಡ, ಎಲ್ಲ ನೋಡ್ಕೊತ್ಕೊಳ್ಳೋಣ ಅವನ್ನೆಲ್ಲ. ಕೂತ್ಕೊಳ್ಳಿ. This petition by the guarantor cum surety of the loan in question seeks to call in question, seeks to lay a challenge to the order dated 18/4/2024 whereby the Debt Recovery Appellate Tribunal at Chennai has negatived petitioner's MA number 40/2023. Petitioner has also sought for the quashment of Debt Recovery Tribunal's order dated 20 June 2023, whereby his application in IA number 724 of 2022 seeking stay of all further proceedings in respondent bank's OA number 173/2015 has been negatived. First off, learned counsel appearing for the petitioner, borrower, surety, guarantor vehemently argues that although his client was admittedly a guarantor having executed a mortgage for securing the repayment of initial debt, his client's liability by virtue of suretyship would stand discharged absolutely because of one, and small a, novatio, in as much as new transaction has been brought about by executing a whole lot of loan documents, and B, there is a fraud and fabrication of documents perpetrated by the borrower, principal borrower, hand in glove with the officials of the bank. Semicolon. He quotes, he cites decision of the apex court in P. Changalavaraya Naidu versus so and so, to the effect that all transactions stand voided by virtue of fraud, fabrication, and duplicity. First. Secondly, he submits that he is a civil suit in OS number ಏನೋ ಕುತ್ಕೊಂಡೆ ಹೇಳಿ.
Yes, ma'am.
OS number
688 of 2019, my lord.
688 of 2019, founded on fraud and fabrication, is pending, and that the respondent bank herein also happens to be one of the defendants to the same. The lender's bank's application filed under Order 7, Rule 11D
With section 34.
of CPC was favored by the civil court. Void order dated.
Yes, ma'am.
ಕುತ್ಕೊಂಡು ಹೇಳಿ.
4th January 2020, my lord.
Huh?
4th January 2020.
4/1/2020, and the suit was dismissed. Semicolon. The same was put in challenge in then RFA ಆಗ್ತದೆ?
Yes, my lord. RFA, my
In
lord.
RFA number
421 of 2020.
421 of 2020, which came to be allowed by a learned single judge
Yes, ma'am.
of this court. Wide order dated
15/2/2022, my lord.
15/2/2022. And the dismissal of suit having been set at naught, comma, the suit is restored to the trial court for trial and disposal. First, that order of this court would bind the respondent bank as well. Lastly, he submits that the tribunal being the DRT being a creature of law. Mr. Deshpande,
Yes,
the creature ಅನ್ಬಾರ್ದು, creature ಅನ್ಬೇಕು.
Yes.
Creation, creature. Fowler's ಡಿಕ್ಷನರಿಯಲ್ಲಿ ಹಂಗಿದೆ, ನಾನು ಹಂಗೆ ಹೇಳ್ತಿದ್ದೆ. ಒಂದ್ಸರಿ ಬಾಬು ಸಾಹೇಬ್ ಹೇಳಿದರು, creature ಅನ್ಬಾರ್ದು, creature ಅನ್ಬೇಕು ಅಂತ.
Yes.
You're all people will
No.
know, therefore I'm telling you.
Yes.
Bardema? Creature of law, comma, has only statutorily conferred limited jurisdiction, and it tries the causes in a summary way, and therefore has no power to try the complex issues of fraud and fabrication. First, in support of his position, he relies upon certain decisions, certain rulings. First, next panel. After service of notice, the senior, the respondents, ಯಾರ್ಯಾರ respondents ಅಪ್ಪ?
Milord, Reliance yes.
ಒಬ್ರೇನಾ?
Reliance yes.
The respondent financial institution has, and bank ಅನ್ನೋದು ಅಲ್ಲ.
Yes, asset reconstruction company.
Financial institution.
Asset reconstruction company.
Asset reconstruction company has entered appearance through the, ನೀವೇನ್ caveat ಹಾಕಿದ್ರಾ? ಇಲ್ಲ.
Caveat ಹಾಕಿದ್ವಿ.
Has entered appearance through caveat, has entered caveat through their counsel, through its senior panel counsel, who vehemently opposes the petition, making submission in justification of the impugned orders of the DRAT and DRT. First, he refutes the submission of learned counsel appearing for the petitioner, contending that the DRT functions under the provisions of 1993 Act, full Act ಬರ್ಕೋಬೇಕು. Act, semicolon. It has all powers which civil code statutorily do, civil courts do have. Seven. Even the contentions of no issue, limitation, and fraud and fabrication, small and fraud and fabrication, can also be duly adjudicated upon seven. Therefore, the petitioner is not justified in seeking to stall the DRT proceedings one way or the other. First, he also highlights the likely consequences of allowing the borrowers and sureties to approach the civil court to litigate on the issues of the kind and thereby interdicting the speedier loan recovery which the 1993 Act intends. First, he also adds that the suit is essentially founded on the lack of authorities constituted under the Surface Act as distinguished from those constituted under the 1993 Act. First, so contending, in support of his contention, he too banked upon certain rulings. First, having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence as under and for the following reasons. First, number one. initially the loan was taken in the year, a loan of rupees
1 crore 3 lakhs, my lord.
1.03.
1.30, my lord.
1.30 lakh,
1.30 crores, my lord,
1.30 crore.
of term loan, my lord.
Rupees 1.30 crore of term loan
And 3 crores of open cash credit limit.
along with 3 crore open cash
Credit
limit
Yes.
was availed in the year
2010, my lord.
in the year 2010. First up. Petitioner admittedly happened to be the guarantor,
Yes, my lord.
cum surety, and to secure repayment of the loan, he had mortgaged his property
Yes, my lord.
in favor of the document also was registered on date ಹೇಳಿ.
25
5/7,
July
2011.
2011.
Huh?
25/7,
2011.
2011.
25
ಇದು 3 ಕೋಟಿಗೆಲ್ಲ 7.5 crore ಗೆ 3 crores initial loan. It is enhanced to 7.5 crore. 7.5 crore ಗೆ ಅವ್ರು mortgage ಕೊಟ್ಟಿದ್ದು. Registered mortgage is for 7.5 crore.
ಅಲ್ಲಿ ಎಷ್ಟು ಮಾಡಿದ್ರು ಫಾರ್ 1.3 crore earlier.
Initially 1.3 and 3.
1.3
and 3 OCC. 1.3 for term loan and 3 crore for OCC.
OCC.
And later, my lord, 7.5 crore.
ಫಸ್ಟ್ ಅದು ಅಲ್ಲಿಗೆ ಸೈನ್ ಅಪ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿಗೆ ಫುಲ್ ಸ್ಟಾಪ್ ಅಲ್ಲಿ ಅಲ್ಲ in the year 2010. First stop. Subsequently,
on 14/7/2011,
on 14/7/2011,
enhanced to 7.50 crore.
The loan limit came to be enhanced to 7.50
crore. ಹೌದು.
7.5 crore.
ಹೌದು, 7.5 ಕೋಟಿ.
Crore. And
the petitioner executed a mortgage deed.
Payment of the entire loan was secured by execution and registration of mortgage of the subject
on 25/7/2011.
Date,
on 25/7/2011.
Dated 25/7/2011.
7 and also guarantee.
Correct?
Yes. And guarantee also executed.
A letter of guarantee also came to be executed
on 16/7/2011
by the petitioner on 16/7/2011.
Yes, ma'am.
2011. First, these facts are not in dispute. Next paragraph. ಮುಂದಿನ subsequent enhancement ಎಲ್ಲಿಗೆ ಹೋಯ್ತದು?
That was from 7.5, another 2 crores was credit facility was given. It was enhanced.
ಯಾವಾಗಿದು?
It was on 6/11/2012.
The credit facility limit came to be enhanced to rupees.
My lord, according to them, it is 10 crores. According to me, it is 9.5, but it can be mentioned as 10 crores. My lord.
Rupees 10 crore. 10 crore. 10 crore as well. In that connection, the principal debtor had executed certain documents.
Yes.
And it is the case of petitioner that certain documents were fabricated as purporting to have been executed by the petitioner himself.
Which I am disputing. Which I am disputing. I am saying that this is his own signature.
This is militantly disputed by the senior panel counsel appearing for the asset reconstruction company. First. Next paragraph. In relation to alleged fraud and fabrication, as already mentioned above, petitioner has instituted a suit in OS number 688 of 2019.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನಾನು OA ಹಾಕಿದ್ದೆ.
First.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ನಂದು OA. ನನ್ನ 2015 OA. ಅವ್ರದ್ದು 2019 OS.
In the meanwhile,
I classified the
The-
account NPA.
Respondent Asset Construction Company, ACC, had instituted OA number
173 of 2015.
173 of 2015
Before the Debt Recovery Tribunal, Bangalore.
before the Debt Recovery Tribunal 2, Bangalore. Correct? Huh?
Wala, Debt Recovery Tribunal, Bangalore.
Bangalore.
I have one day.
DRT
On 30th 1 2015.
Bangalore on
30th 1 2015.
30 January 2015. First. ಅದರಲ್ಲಿ ಅವರು WS ಯಾವಾಗ ಹಾಕಿದ್ರು?
WS ಹಾಕಿತ್ತು ಸ್ವಾಮಿ, ಒಂದು ನಿಮಿಷ. Return statement filed it on my lord.
27th March 2019.
Petitioner herein had filed his WS on 27
March 2019.
2019.
Yes.
Resisting the OA. Inter-alia on the ground of fraud and fabrication.
They
ಆ
admitted-
ground 20.
Yes, ma'am. And pendency of the
They
suit. also.
admitted certain transaction, they're disputing certain transaction.
ಅದೇ, first. However, he has admitted the transaction to the tune of rupees 10 crore.
No.
10 ಅಲ್ಲ,
7.5. ma'am.
7.5 crore.
Yes.
To the tune of 7.5 crore. First. Petitioner had moved an application before the DRT
Yes, ma'am.
On 25/3/2022.
on 25/3/2022,
2022.
filed under section 10 of
22(2)(h).
CPC, read with section
22(2)(h). ma'am.
22(2)(h), read with 151.
22(2)(h), read with 10 of CPC.
No, no. Read with 151 of CPC.
Read with 151 of CPC, H of 1993 Act, read with section 151 of CPC, seeking stay of DRT proceedings.
Yes.
Proceedings. First. The said application having been turned down, comma, petitioners MA number
Yes,
40
40
of
of
2023.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಸ್ವಾಮಿ, IA ಆರ್ಡರ್ 170 ಇದೆ, that DRT dismissed it. MA is subsequent to my lord DRT order.
Correct. Correct. I was dismissed.
Dismissed.
On the turn down. ಅದಾದ್ಮೇಲೆ
20th June 2023.
on 26,
2023 by the
June?
DRT.
20 June 2023.
Yes, my lord.
First off.
Detail order.
Comma. The the Miss MA number 40 of 2023. Petitioners MA number 40 of 2023 at the hands of the DRAT met the same fate on
18th April 2024.
18 April 2024.
24.
First. Next point. The vehement submission of learned counsel for the petitioner guarantor that once there is novatio, a new arrangement comes into existence and eventually the surety is discharged, not only pro tanto, but absolutely need not be gone into by this court, since such a contention is wide open for being treated by the DRT after the evidence is recorded. Whether in the given scenario, a surety is discharged or not is essentially a mixed question of law and facts, and therefore that cannot be treated by this court, exercising a limited supervisory jurisdiction under Article 227 of the Constitution of India, Article 226, having been ornamentally employed in the petition. Vide. Mirajkar versus so and so, 1965 Supreme Court phase 1 event. But it Mirajkar versus so and so. Next point. The next the same applies to the contention of the petitioner as to the limitation, as to the point of limitation as well. First, it hardly needs to be reiterated that limitation is always a mixed question of law and facts. First, next paragraph. The above being said, there is force in the submission of learned counsel for the petitioner that the tribunal, that is DRT, is a creature of law, having been created under the provisions of 1993 Act, and it would follow summary procedure in treating the bank's causes brought before it. Apparently, the fraud and fabrication need examination in detail and deeper consideration would be warranted, which the DRT by its very nature cannot undertake. Therefore, the suit of the petitioner is rightly remanded for trial by a learned single judge of this court in petitioner's RFA number so and so, to which the respondent RCC is a party nomine, and therefore it binds him as well. Full stop. Next paragraph. The vehement submission of learned counsel, senior panel counsel appearing for the RCC, that the power of the DRT is coextensive with that of the civil court, and therefore it can undertake examination of issue as to fraud and fabrication is bit difficult to countenance. And reasons for this are not far to seek. As already observed above, the tribunal is not an absolute substitution for the civil court. Semicolon. Secondly, it follows the summary procedure, object of the proceedings before it being to secure speediest recovery of outstanding public debts. Seven. Thirdly, exclusion of jurisdiction of the civil court is not readily inferred. Semicolon. Courts are always jealous in treating the argument as to lack of their jurisdiction. This view gains support from the Constitution bench judgment of the Apex Court in Dhulabai versus State of MP, AR 1968, Supreme Court, page 78, 74, wherein postulates have been made and case of the petitioner would arguably fit into postulate number 3 or 4. The reliance placed by learned panel counsel on the decision, on the rulings do not controvert this position. Okay. ಅಲ್ಲೇ ಮೇಲ್ಗಡೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅವ್ರ ಕಂಟೆನ್ಷನ್. The above view having been considered under the ಇದೇನೋ DRT Act 93 Act ಅಥವಾ 2002 Act ಅದು ಡೆಲ್ಲಿದು.
This is under the
ರಾಜನ್ ಮಲ್ಹೋತ್ರಾ
RDB Act.
93 Act itself.
Yes, ma'am. Yes, ma'am.
Sentence. Learned counsel for the petitioner is justified in seeking succor for his submission by placing reliance on a division bench judgment of Delhi High Court in Rajan Malhotra and another versus Union Bank of India, 2019, SEC online, Delhi 11177, wherein substantially similar issue was debated under the 1993 Act. First off, the Apex Court in Kusum Ingot versus so and so has opined that where a high court decides a question of law under a central legislation, ordinarily that view would be binding upon other high courts. Kusumin got binding. In a sense, it is more than persuasive. First off, AR 2010 ಯಾವುದೋ ಒಂದಿತ್ತಲ್ಲ, ಸಿಂಚನ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು ಡೈವರ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಜಸ್ಟಿಸ್ ಸೆಟ್ಟಿ ಅಲ್ಲ ಜಸ್ಟಿಸ್ ಡೈವರ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಕುಸುಮ್ ಇನ್ಗಾಟನ್ ಫಾಲೋ ಮಾಡಿ ಕೇರಳ ಹೈಕೋರ್ಟ್ ಕೊಟ್ಟಂತ ಆರ್ಡರ್ ಇಟ್ಸ್ ಬೈಂಡಿಂಗ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಚೆನ್ನಾಗಿ ಕೇಳ್ಕೊಂಡ್ ಬರೀಬೇಕು. Refer to division bench judgment of this court. Division bench of High Court on Kusum Ingot and Google go. Okay. Next paragraph. The reliance of one sentence counsel for the petitioner fairly said that this decision of Delhi High Court is put in challenge before the apex court in SLP number so and so, so and so. No stay has been granted?
No stay.
And that no stay has been granted there too. The next paragraph. The vehement reliance of learned panel counsel on the decision of apex court in Messrs. NN Global Mercantile Private Limited versus Messrs. Indo Unique Flame Limited. Civil Appeal number 3802-3803 of 2020 does not come to his rescue. First off, at paragraph 8.16, the apex court has observed 16 and 17 has observed as under. First off, it was a case arising under the Arbitration and Conciliation Act 1995. 95 or 96? 96. Wherein court deviated from the conventional stand that arbitrators could not decide the issues of fraud and fabrication and held that now they can. First. So this is not a case relating to banking law at all, and therefore cannot be cited as an authority in support of law relating to banking.
Scrap Industrial Credit and Investment Corporation versus Scrapco Industries, 1999 4 SEs, 710. Power of 20. 1999 4 SEs. Separate separate power under section 22, my lord. My lord said in the morning, any judgment you can able to pull out.
The second, next paragraph, the second ruling, Industrial Credit and Investment Corporation of India Limited versus Grapco Industries Limited, 1999, SEC 710, also does not come to the aid of the respondent, rescue of the respondent. Full stop. Matter essentially there related to grant of interim order and their interim orders and their continuation or variation at the hands of the DRT whilst exercising power under section 22 of 1993 Act. Full stop. Whether the DRT can decide the complex issues like fraud and fabrication did not fall for consideration even in the penumbra of the fact matrix. At para 11, the court observed that the powers of the tribunal in matters of granting interim reprieve are coextensive with that of the civil court. First, thus,
Third one judgment ಮಾಡಿದೆ.
This court, this judgment too, this ruling too does not avail. Next
That Bank of Rajasthan, my lord, versus VCK shares, page number 38 ಅಲ್ಲಿ, that compilation of judgment. The compilation of judgment filed on, my lord, 1st July 2024. Para 43, 44, 45.
Bank of Rajasthan.
ಹೌದು.
ಅದೇ
My
ಓದಿದ್ರು.
lord, compilation filed on 1st July 2024. So, ಅದ್ರ ಮೇಲೆ argument, mainly upon. ಈ judgment.
The third recent ruling of the apex court in Bank of Rajasthan versus so and so 2023 1 SEC 1 also does not lend credence to the contention of the respondent. Full stop.
Para 3, 4.
At the paragraph 43 and 44, it is observed as under. First, at the paragraph 53, 54 and 56, it is observed as under. What is significant to note is the absence of the issue as to DRT's power and competence to decide the complex issues like fraud and fabrication. That issue had not cropped up in the said decision. First, Lord Halsbury in more than a century ago in Quinn versus Ledham, 1901, AC, just a page of 495, observed that a case is an authority for the proposition it lays down in a given fact matrix, and not for all that, that would logically follow from what has been so laid down. Full stop. Next paragraph. There is all the above being said, we do not agree with the submission of learned counsel appearing for the petitioner that the proceedings before the DRT on merits should be interdicted till after the pending suit of his is tried and decided. First stop. A contra contention, a contra view would defeat the very idea of speedier recovery of public loans, outstanding public loans, as rightly contended by learned panel counsel appearing for the company. First, some via media has to be made in matters like this, so that no injustice is done either to the lender or to the borrower. First, in our considered view, that can be achieved by permitting the DRT to proceed with the matter as if there is no suit at all, and to permit the suit to proceed with the suit, permit the court, civil court to proceed with the suit as if there is no DRT proceeding at all, till, of course, till a particular point of time or stage. First off, if the DRT grants the decree as prayed for by the respondent company, the same can be executed against all the properties except the one which has been furnished by way of mortgage security, securing the repayment of loan. First, if the civil court turns down the suit of the petitioner, then the decree comprising the mortgage debt also becomes proprio vigor enforceable. First off. This we are doing in the peculiar fact matrix of this case. First, in the above circumstances and with the above observations, the writ petition is disposed of. First, both the DRT and the civil court are requested to try and dispose of the causes pending before them as expeditiously as possible, keeping open, first that all contentions of the parties are kept open, subject to what has been commented upon. Wait, ಇಬ್ರಿಗೂ ಮುಗಿಸ್ಬೇಕು. ಅಲ್ಲೇ many other contentions were taken up and rulings were cited, but we did not find them relevant, and therefore we did not intend to lengthen the judgment. We should appreciate both of you, and really I should appreciate you because we were dead against this cause actually. Some of you argued very well. This court places on record its appreciation for counsel appearing for the petitioner Shri so and so, counsel appearing for the bank so and so.
Grateful. We are grateful. Rarely we will get opportunity in these type of matters, my lord. Fraud.
ಅವಾಗೆ ನಾವು ಕಲಿಯೋದು. ನಮ್ಗೂ ಹಂಗೆ ನಿಮ್ಮಂತವರೆಲ್ಲ ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡಿದಾಗ ನಮ್ಗೆ ನೋಡಿ ಆ ಕ್ವಶನ್ ಇದೆಯಲ್ಲ, ನಿಯರ್ಲಿ ಅಬೌಟ್ 15-20 days ಆತಿದ್ದು ಹಾಕೊಂಡು. Till date I do not have correct answer. But one view ಏನಿದೆ, question is discharge ಅಂದಾಗ entire discharge, it cannot be half at all ಅಂತ ನಿಮ್ದೊಂದು ಕಂಟೆನ್ಷನ್ ಇದೆಯಲ್ಲ. ಇಟ್ಸ್ ಅ ವೆರಿ ಬ್ಯೂಟಿಫುಲ್. ಅವ್ರಿಗೆಲ್ಲ ಚಿಟ್ಟಿ ಆನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ನೋಡಿದೆ ನಾನು, ಆನ್ಸನ್ ಆನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ನೋಡಿದೆ, ಚಶೈರ್ ಫುಟ್ ಅಂಡ್ ಫರ್ಮ್ಸ್ಟನ್ ಅನ್ಕೊಂಡು ಇನ್ನೊಂದು ಫೇಮಸ್ ಬುಕ್ ಇದೆ, ಅದನ್ನು ನೋಡಿದೆ ನಾನು. ಅದೆಲ್ಲೂ ಅಂತ ಕ್ಲಾರಿಟಿ ಸಿಗ್ಲಿಲ್ಲ. ಮೇ ಬಿ ಕ್ಲಾರಿಟಿ ಯಾಕೆ ಸಿಗಲ್ಲ ಅಂದ್ರೆ ನೀವು ಹೇಳಿದ ಪ್ರಿನ್ಸಿಪಲ್ ಇದೆಯಲ್ಲ, it must be universal. So to contradict that, I need literature, but I don't want to take risk in this matter because he also argued so well. Yes, let it be decided in all contention.
Grateful.
Okay. Hey, appear for the petition. You are for petitioner. Chandrasekhar is here. Not here.
Not here.
But on the other date, what vote?
Yes.
call this matter on such and such date to enable respondent party in person to come and argue.
Interim order. Interim order vacate.
Interim order to continue. Correct. ಇನ್ನೊಂದಿದೆಯಾ?
Appearing for the respondent, Your Lordship, the matter is very simple.
Very simple.
The order,
As simple as your mask.
I apologize, Your Lordship.
No, it's all right. You are entitled to wear that. After all, that apparel is not prohibited under Bar Council rules.
Your Lordship, an order was passed by the District Commission and they are challenged before the state consumer. That state consumer had dismissed their petition and that order, their appeal was dismissed and that appeal has been challenged before this honorable court under section Article 226 of the Constitution, Your Lordship. Your Lordship, as you...
227 also.
Yeah, 226 and 220. As Your Lordships are aware, it's a very settled law that when there is a alternative remedy available as per the act,
Alternative remedy.
Your Lordship, 1 second. They can approach National Consumer Commission, Your Lordship.
Okay.
Citation.
Idea? Second appeal idea?
Nothing, my lord. She
No
is saying
second
that
appeal.
we have to approach the National Commission, my lord. But instead of that, we have preferred an petition before this.
Where is the second appeal?
Your Lordship, after, if appeal is dismissed from the state consumer, it has to be appealed before the national.
That section, read it. Read.
One citation.
ಓದಿ ನೋಡೋಣ ನಮ್ ನೆನ್ಪುಳಿತದೆ ಓದಿದ್ದು. Especially ನೀವು ಓದಿದ್ದು ನೆನ್ಪರೋದಿಲ್ಲ.
Okay.
ಓದಮ್ಮ ಓದು.
Appeal to the National Commission, any person aggrieved by an order made by the State Commission in exercise of its powers, conferred by subclauses 1 or 2 of clause A of subsection 1 of section 47 may prefer an appeal against such order to National Commission within a period of 30 days.
ಅದಕ್ಕೆ ಹೇಳಿ ಬರಲ್ಲ ಅಂತ. That is where the state commission exercises original power.
Your Lordship, there are citations also of Supreme Court which has stated. One second.
ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Sir.
These are all settled matters. There is no second appeal.
First
appeal, state commission ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಅಂದ್ರೆ ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಇದೆ.
Being by that appeal, we have to prefer an appeal before the National Commission, my lord.
Your Lordship, one Supreme Court 2021 judgment ಇದೆ.
ಏನು?
The High Court, after having held the writ petition to be maintainable, has dismissed the writ petition on merits. Despite the attention of the High Court having been drawn to Sicily, another Supreme Court judgment, without even dealing with or discussing the judgment and reason of its inapplicability. The High Court has chosen to rely upon the decision of a single judge of Orissa High Court and Division Bench of...
ಅಲ್ಲಿ Precedent in English law ಅನ್ಕೊಂಡು ಒಂದು ಬುಕ್ ಇದೆ.
Yes, sir.
ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು? How not to read a judgment ಅಂತ ಹೇಳ್ತಾರೆ. ಅದನ್ನೆಲ್ಲ ಓದ್ಕೋಬೇಕು. ಮೊದಲು ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂತ ತಿಳ್ಕೋಬೇಕು. ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮಿಗೆ ಹೋಗಿ ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಇದೆ ಸ್ಟೇಟಿಗೆ ಪೂರ ಕೇಳ್ಕೋಬೇಕು. ಅವಸರ ಮಾಡ್ಬಾರ್ದು, ಅವ ತಿಳಿಯಲ್ಲ ನಾ ಹೇಳೋದು ಅದಕ್ಕೆ. ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮಿಗೆ ಹೋದ ನಂತರ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಯ್ತು ಅಥವಾ ಅಲ್ವಾಯ್ತು, ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಇದೆ ಸ್ಟೇಟಿಗೆ. ಸ್ಟೇಟ್ ಕಮಿಷನ್ಗೆ ಹೋಗ್ಬೋದು. ಸ್ಟೇಟ್ ಕಮಿಷನ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತು ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಇಲ್ಲ. ನಮ್ CPC ಕೆಳಗಿದೆಯಲ್ಲ ಸೆಕೆಂಡ್ ಅಪೀಲ್, ಆ ರೀತಿ ಇಲ್ಲೇ ಇಲ್ಲ, ಹಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಮೋಸ್ಟ್ಲಿ ಫಾರ್ ಯು ದಿಸ್ ಇಸ್ ಫಸ್ಟ್ ಕೇಸ್, ಬಟ್ ಫಾರ್ ಅಸ್ ಮೆನಿ ಕೇಸಸ್ we decide. Anyway, we appreciate your effort. Therefore, look into all that. Whether second appeal, this is a case of second appeal which you are saying.
Yes, sir.
This is first appeal ಮುಗ್ಕೊಂಡು ಅದಾದ್ಮೇಲೆ ರಿಟ್ಟಿಗೆ ಬಂದಾರ ಅವ್ರು, ಆಯ್ತಾ? ಅದಕ್ಕೆ ನಿಧಾನವಾಗಿ ಕುತ್ಕೊಂಡು ವಿಪಾ ಪಿ ಸಾರಥಿ ಅನ್ಕೊಂಡು ಒಂದು ಬುಕ್ ಇದೆ, ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಮೇಲೆ, ಒಳ್ಳೆ ಪುಸ್ತಕ, ಅದರಲ್ಲಿ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಓದ್ಕೊಂಬರ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಹಾಕೋಣ. ಬಟ್ ವಿ ಅಪ್ರಿಶಿಯೇಟ್ ಯು. ಶಿ ಆರ್ಗ್ಯೂಡ್ ವೆರಿ ವೆಲ್, ಇಸ್ ಇಟ್ ನಾಟ್? ಯಾವ ಡೇಟಿಗೆ ಹಾಕೋಣ?
Any
Short
short-
date may
but
be
my lord,
given, your lordship.
well,
Senior
submission
will
before
come
this
on.
court, if court permit, I will address short.
No, what matter, Papa. She is not fully
Please, Your Honor,
prepared.
please, please,
She
please.
came under impression that this covers the.
Please, Your
matter.
Honor,
Let
please.
her read and come back. She argued so well.
Please, Your
Ah. All right. Call this matter, week after next we'll have it.
A date may be given, your
All
lordship.
right, one date. ಯಾವ year ಇದು?
2024, your lordship.
24 date.
second week of February, my lord.
Second week of February.
Your
Second
lordship,
week of-
ಅದು execution stay
There is
ಆಗಿದೆ,
already
ಅದು 2016 in the case.
2016.
ಅದು district consumer
2712, since 2712, there is execution proceeding stay ಆಗಿದೆ. So
ಇಲ್ಲ, ಅದು
but after
ಕೇಸ್
that-
ಇನಿಷಿಯಲಿ ಫೈಲ್ ಆಗಿದ್ದು 2016 ಅಲ್ಲಿ, ಅದು ಆಮೇಲೆ ಡ್ರಾಗ್ ಆಗಿ 2024
Gone,
ತನಕ
gone, gone.
ಬಂದಿದೆ.
Second week, ತಕ್ಕೊಳ್ಳಿ. Second week of February. Call this matter.
Your lordship, I apologize, date may be given.
ಹೇಳಿದೆಯಲ್ಲ, second week ಅದು. Second week, entry ಮಾಡ್ತು.
kindly accept, please. Grateful, Your Honor.
Your lordship, we
yeah.
pray that it may be extended only till next date.
Till next date of it. You are right.
Oblige, Your Honor.
ಎಲ್ಲಿ ಹೋಗಿತ್ತು? ಓ. ಗೊತ್ತಾಗಿಲ್ಲ. ಏನ್ ತೆಗೆದಾಕ್ಬಿಡು. ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಕ್ಕಂತ. ಅದು ಹಂಗೆ ಹೋಗಕ್ ಸಾಧ್ಯನೇ. ಫೈಲ್ ಏನು ಯಾರ ಒಂದು ಉಪಯೋಗ ಮಾಡ್ಸೊಳಕ್ ಬರ್ತದೆ. ಅದಕ್ಕೆ ಯಾವುದೇ ಫಂಕ್ಷನ್ ತೊಳಿ ಅವಸರ ಮಾಡಬಾರ್ದು. ಸ್ವಲ್ಪ ಶಾಂತವಾಗಿ ಹಿಂಗಾಗಿರ್ತಾವ ಅದಕ್ಕೆ.
Friday ಕೊಟ್ಟಿದ್ದಾನೆ ಎಷ್ಟೊತ್ತಿಗೆ ಇದ್ದಾಗ Monday next Monday ಡೇಟಾ ಕೊಟ್ಟಿದ್ದಾನೆ